What's up, everybody? Welcome back to the internet where your cesspool is my jacuzzi. Sorry for being late. I am in San Francisco again. Got here this afternoon a lot later than I was supposed to, which means I had to work a lot later than I was supposed to. Flights from LA airport were delayed all day, so I got delayed 4 or 5 times because there was some kind of bomb cyclone here, and I have never even heard that term before. So I was like, what? You mean somebody bombed something? And no, apparently it's just like a really bad storm that has like hurricane force winds and stuff. And I still don't really quite understand it. But it was pushing me back all day. So unfortunately, I might be stuck in San Francisco for longer than I anticipated because it is expected to be very windy tomorrow as well. So here I am for who knows how long. So as you guys know, while I'm gone traveling, the audio video quality is going to be subpar, so I'll do the best that I can. If it gets really bad, just let me know. I'll pop some headphones in, see if that makes it any better, but I got what I got, you know. Also, if I look like red as hell, it's because the lighting here is really strange. That might be a little better, but honestly, I don't know. I'm a mess right now just from traveling. Like, I don't know about you guys, but after a long day of traveling, I feel like crap. And I mean, I'm going to be very frank with you guys right now. I smell like a raccoon farted in a dumpster. Like, it's pretty bad. I need to take a shower, but I wanted to get through work first because the first thing I had to do when I got here was plug in my workstation and get to it. So yeah. Winks, hey, how you doing? Bruce, I'm going to have Bruce come in here. I'll see if Snizzle Ninja is available. I'll have Bruce come in here when we start talking about the appeal and the bar complaint. And Patrick, my friend, who was in here during our live stream in court, answering you guys' questions, he's a lawyer too, will be joining us to discuss that as well. So the new PDX terminal is very nice. Shit, Bruce, I'm coming to your house. So I want to talk about this now that I'm back in the States, and trust me, it was a long journey back to the States. I want to talk about this copyright strike and what happens next. And I know I've talked about it a little bit, but I was pretty heated. It was still pretty fresh. I was mad that the guy, gave me a copyright strike on my birthday. I was like, what the fuck is wrong with you? But, I've had some time to think about it. I'm just chilling out, just chilling out. Atomic camel knuckle. What is a camel knuckle? I know what a camel toe is. I don't think that's what you're talking about, though. So, guys, I don't actually care how long the appeal is. I just think it's funny that the lengthy thing became such a big deal. So I was just kind of like making fun of it. Like, sometimes I do just make jokes just to make jokes. I'm not trying to be malicious or anything like that. Like, I don't know, dude. Like, I want to be very clear. Like, I'm not a lawyer, as you guys know, as everybody probably knows. I'm not a lawyer. And so I know that David Gingras knows the law, like, in a way that I probably never will. Yeah, that doesn't mean he's always going to be right about everything all the time. But I know that he has, been trying very hard to get it right. So I think that if he needed to write a 70-something page appeal, fine. That's fine. I couldn't tell you, like, would it have been done better in less words or less pages? Like, I couldn't tell you that. He made it within I believe there was a word limit. And the reason I'm coming out of the gate here and not being super critical is because I have had my kind of humanity pushed and questioned by David and his client. And I don't know if that was intentional or not, several times in the last 9 months or so. And I've just been thinking about that a lot. I had a long flight to think about it. So, but yeah, like Bruce says here, lengthy is not an insult, just a qualitative assessment and commentary. And I just, like, I agree. I totally agree. But, like, the thing is, like, it just became such a thing, with, especially when he used the thumbnail with Dave's lengthy appeal comment and the clown face. I'm just kind of like, okay, guys. So, all right. So here's what has to happen now. First, I'm going to tell you what has to happen, okay? And then I'm going to explain to you why I think he should not move forward with a lawsuit. And if he decides to, then that really tells me all I need to know. So what happens now is I have to submit a counter complaint. Not a complaint. What is it called? A counter notification, which is starting a legal process. I know I said Omar was going to help me draft it, but Omar is sick right now, guys. And I have I have other friends who work in law, and I have one who's willing to let me use him, to do this. And I don't know how that will work out if he proceeds with a lawsuit. Like, I don't think I really want to put that on my friend. Like, hey, dude, I don't have any money. Can you help me out here? Like, because that seems like a shitty thing to do. But at the same time, it's like, I don't have any money. What am I going to do? Because like I just told you, I don't know the law up and down. I'm not a lawyer. What I do know is how YouTube and fair use works on YouTube. And what I do know is what my intentions were behind commenting on his video and sharing and showing a lot of it. I'm not saying David knows nothing about copyright law. I'm not questioning his ability to read a law book. I'm saying David doesn't know anything about me. He doesn't know anything about my intentions, and he admitted himself he did not watch the video that he struck. So I was actually being very almost complimentary. I was being very kind and understanding and like trying to be almost encouraging towards him. I was trying to warm up to the guy, right? And you could see that in the beginning of my video. When it starts to go south is when he pulled that weird thing where he started tweeting about filing with the copyright office and all that stuff. And I'm just like, that's not like, what are you doing? Why are you doing that other than to hurt someone? Because if he had watched the whole video, he would know that the first thing I did was say, I know he put a lot of work into this, and I don't want to be a dick. So I'm going to show the video from his channel, refer to the direct source. I'm going to give him credit for that. I want to give him this click, right? Like, I'm not going to pretend that he's not the one who made this. So that was the first thing I said. The second thing I said is like, I don't want to hurt the guy's feelings. I don't want to take away from him telling his own story. I don't want to like show him talking about his cat and stuff, because that's him. That's his creativity, his story, his life. And so I didn't want to do that, right? So I skipped over some stuff when I could remember, but admittedly towards the end, I was like very kind of rattled and almost distressed, because I was like, this guy's actually just like coming after me for no reason. But he doesn't know. Like, he doesn't even know what he's talking about. And it has nothing to do with the law. It has nothing to do with his knowledge of copyright law. It has everything to do with him trying to be personable and try to listen to people and understand what they're saying and where they're coming from. Because if he had listened, he would know that I was actually not someone who was trying to take away views from him. I actually turned off monetization on my video because I read his tweets and I found out that would upset him. So I turned it off. I did not steal his video and tell everyone like, hey, watch mine instead. You know what I mean? Like, of course I like put links to my video out there and I'm like, hey, I'm commenting on this video or whatever. And honestly, to be honest, I did stand up to him a little bit because he was saying something beforehand that is not right and it's not legal, which is if any JFC YouTuber uses any part of my video, I will sue them. You cannot do that. I know that much. You cannot do that. And so me calling him out on that, I stand by that. I stand by what I did. I don't agree that that was meant to hurt him or his ability to make money off of his own work. Number one, his video was not eligible for monetization. Number two, I turned my monetization off. So I don't really understand that at all. It's like David makes this assumption that we are all the same. And that's where his downfall is, as far as like his trying to do PR and stuff like that. I think David assumed that I am the person behind JFC Twitter. David probably assumed I'm the person behind JFC Instagram. I am not. I am one person from the state of Florida, far away, right, from Arizona, which, by the way, I think the copyright lawsuit will have to happen in Florida, I'm pretty sure, because I'm not under Arizona jurisdiction. I'm not 100% right about that. I just question that, right? So I question that. So my thing is, like, I grew up in Orange Park, right? I didn't know any of these people until what, like 6-7 months ago, and these are people that like have become my friends because we've, you know, bonded over shared experiences and stuff like that. And the root like thing that brought us together is like people feel wronged by what his client has done. People feel like what she's done has hurt them in a way because it's really affected our like means of being taken seriously as people who have been abused, as people who have suffered from cancer or miscarriage or anything along the lines of what she's allegedly faked. And I believe that I'm right about that. I believe that. And I think that David and I don't understand each other because we both really believe we're in the right. And that's unfortunate. Not because I think necessarily that I'm better than him, but I believe that my stance here, my position here is the correct one. I believe that I am on the right side of this. I don't want to say like this guy sucks, you know, and I probably have. I probably have, because when he pulls stuff like this and he is saying he's going to sue me for up to $150,000 for providing non-monetized commentary on a non-monetized video where I transformed it from a 45-minute video into a 2.5-hour video, right? And I skipped over his personal stuff. So when he says stuff like that, like I believe I'm in the right. Yeah, I do. And I don't think I'm necessarily better than him. Like I don't think I'm better than anyone. What I think is that my position on this is the correct one. So like I'm trying to say this like a million different ways, but like it's not right. And like I've said at the beginning of most of these streams, I'm not a lawyer. I'm not a doctor. I am what I am. Like I know behavior. I have experienced many of the things that Laura Owens has experienced, and that makes me a decent judge of character in that regard. It makes me able to see red flags differently than like a random person might. And so it pisses me off, yeah, when she makes accusations that I believe are false. And so this is like a huge, serious like injustice to a lot of people, and David is just acting like that doesn't matter, and he groups us all together, and then he wants to punish us. So like here I am now, but I don't believe that I should back down on this. I don't believe it was the right thing to do for him to A, lump me in with a bunch of other people that he doesn't know, right? And B, try to punish me, try to use his position as an officer of the court to ruin my life because he doesn't like something that I'm doing. I don't believe anyone should ever use their position of power to do that to people, okay? And I don't know. Maybe I lose, right? Maybe I lose. But at least I can live with myself knowing that I did something about it, because I've been in so many situations where there was nothing I could do, where I just felt helpless. And I don't feel helpless right now. I feel like I have the power to stick up for myself, at least. I have the power to, you know, like take the things that I give a shit about and say, hey, you can't just dismiss this. This matters. So, yes, it matters that I was kind to him. It matters that I did refer people to his original source. It matters that I did skip over some stuff because I didn't want to take away from what he was doing. It matters that I said I, care that he put in the effort to do this, and I encourage people to actually listen to him talk about it. So, I don't really know what else to say. Bruce, hold on, guys. Sorry. He said, 1, commentate on the first video. 2, don't use any of the second video. 3, use 5 minutes of the third video. He's trying to be YT zaddy and make arbitrary rules to change every day. Well, that's also the problem here is like you're not like the freaking overlord of YouTube. Like you don't get to decide how much is fair use or what's fair use. Like that's not how that's going to work, man. And so when I write this response, and I am going to write the response, I am going to start the legal process. That's what I'm going to say. I'm going to tell the truth. I'm going to tell it from my point of view, what happened, and why he's wrong in his assumptions about me. And I'm going to do the best that I can, dude. Like, that's all I got. All I can do is the best that I can. So, and if he's sincere about being a better guy, then he'll listen. He'll read it and actually consider what I'm saying, and he'll drop it. And if he doesn't, then that tells me all I need to know about the guy. That tells me that I can finally stop trying to hold on to this little bit of faith that he is like a decent human being. All right. Because like I get fired up sometimes and I call the guy some names that are not so nice. I definitely call Laura some names that are not so nice. But at the end of the day, I'm the one who stuck up for his clients when people were making fun of her looks. I'm the one who says, no, do not talk about her eating disorder. It's not right. I'm the one who says, I think it's an accomplishment that she, does what she does with her horses. And I think that it's, I don't blame her for like competing in whatever category she's in. I still think that's an accomplishment. I think that she should lean into that, do something with her life. I'm the one here trying to humanize her. And he's coming after me. So yeah, how this man decides to handle this says everything. If he is sincere, if he's just, trying to be a decent guy and trying to do better, then he'll do better. He will do better. If he doesn't mean what he's saying and he wants to stick to his old habits and this is just who he is, then he'll sue me for however much he wants to sue me for, and I will fight it. Because I'm tired of people using their positions of power to pick on the little guy or to let things slide that ruin the little guy's life. I'm tired of it. And this is the first time I think that I've ever really been able to put dig my feet into the ground and say, no, enough is enough. Like, I'm not dealing with this. This is not okay. And I'll go to court if I have to go to court. I don't want to. Of course I don't want to. I don't want to be sued by the guy. I don't even want to talk to him. Like, I was still trying to be nice to him and be nice about his channel and all that, even though I don't want to talk to him. I was doing my best, But again, he made me question my humanity because he did not watch the video, made assumptions about me, made assumptions that I was like somebody from JFC Twitter or anything else. And he went ahead and struck my video down. And you know what? There's nothing wrong with people from JFC Twitter or JFC Instagram or whoever. Like, there's nothing wrong with them saying, we don't want to watch your video. And the reason that people aren't going to want to watch your content is because you're being an asshole. Like, if you want to be a person that people want to watch, then you have to listen. You have to actually pay attention to who your audience is. You have to stop lumping them all together. Like, I am not a member of a cult. All right, I grew up far away from the rest of my friends that I've made in this movement. I'm a person who's well educated. I did go to school. I have my master's in crim. I'm not a lawyer, but I'm not stupid. You know what I mean? And the things that I have to say, they matter. Right and wrong matters. My idea of what's right is important. And it's more important to me than some dumb nitty-gritty detail about copyright law that this guy may or may not be interpreting correctly. So I just think if you want to be the kind of guy that people support, that people want to support and want to listen to, you have to stop this shit. Because I'm over here trying to see the best in David Gingras. Well, he's only trying to see the worst in me. And I don't always get it right, but I can tell you for sure I never did anything to hurt him on purpose in regards to his YouTube channel. I might have called him some names. I've gotten pretty angry at him sometimes for some of the things he's said and done about people who have been abused by his client, but I never went out of my way to do anything to hurt him or to destroy his livelihood. It's hard, It's hard because I'm like, I don't want to do this, but I do. You know what I mean? Like, I want to fight this, but I don't want to have to. I want to live in a world where I don't have to fight this. I want to live in a world where people don't abuse their power to hurt people. Fuck it. I'd rather risk everything. I'd rather roll the dice, like you said. I'd rather roll the dice. I would. Because people deserve the opportunity to be heard. People deserve the opportunity to live freely and share their perspectives and their transformative content without dealing with this. So AKA the cat lady. Thank you for the $2 retail to Runkle to Bailey for advice. I've not really talked to him very much. I did the other day when he asked for a copy of, the complaint or whatever, and I sent him that, and I was like, hey, just like, blur out the contact information or whatever that was at the end, which, by the way, I didn't notice until afterwards, and I was like mortified, but I'm just doing the best I can over here. So but yeah, I want to emphasize, like, I'm not saying he's stupid. I'm not saying he knows nothing about copyright law. Like, he's an attorney. Of course he knows a lot about copyright law. Okay? I'm saying he knows nothing about me. He knows nothing about who I am or my intentions or why I'm doing or saying what I'm doing, or how I was actually trying to put my bias aside and try to be fair, even though that's difficult as someone who's like been through a lot of the stuff that I believe his client has faked. It's difficult. So I'm trying to say, hey, he put the work into this. Let's listen to the guy. Let's give him a chance. And he's like, fuck you. We're going to court. I'm going to sue you for $150,000, even though you're in debt, working 3 jobs in healthcare, and you're in your own medical debt. Fuck you. That's what he's saying. Fuck you. So he doesn't care. He doesn't care about being a good person. He has got one more chance to show me that he does. But I'm losing my faith here quickly. Tilted lawyer, I got your back sticking on. Thank you, Omar. I appreciate you. Guys, Omar's trying to be really like rational and sensible with this guy. Rational and sensible with this guy, and I hope that it gets through to David. I do. Because I want to see David live up to his potential to be better than he's being right now. Like I said, I'm losing faith that he will be. I'm losing faith that he is actually a decent human being. So, I don't know, man. I'm holding on by a thread here to this little belief that there's more good to people than what they are willing to show us sometimes. So, we'll find out. Sarah Dawn, thank you for the 5, just because I appreciate and admire you. Thank you very much. I appreciate you. Let's see. Bullying and intimidation from a position of power, a lawyer violates the Moose Code of Conduct. Legal Vice says, hey, what's up? What's going on? And Jeff had, tried to give him some guidance and tweeted him and was like really nice about it, but really sensible. And unfortunately, he did not take that advice. And now I'm in this position where I'm going to have to kind of fire back and be like, hey, man, you can chill out. Now, you can be better than this, or you can try to destroy me. And we're going to find out soon enough, guys. Not soon enough. So, but we are also here to go over the appeal document that dropped, and I have my friend Patrick, the lawyer. Sorry, I'm reading his message right now. He'll be ready in 15. Okay. And I'm going to send an invite to Bruce right now. And then I have some screenshots from David's video where he was talking about Judge Motto's complaint. I did not watch it because I don't actually want to watch David talk about me and like copyright law and all that. I don't want to see it. So I don't watch it, right? I like muted it and I put some screenshots on, and it sucks because I'm like, I'm kind of interested in what he's saying, but I can't listen to it because at any moment he might just dig in and be an asshole. So, yeah, it's unfortunate, but we'll look at those and we'll look at the appeal. Might not read the whole thing. King Salmon did DSG file the suit against Lauren? Not yet. I have to file my counter notification first, which I'm going to do before I leave San Francisco, which will be tomorrow. So we'll see how it goes. I'm in a position where it's kind of like people think that he won't sue because he doesn't have a case and it doesn't make sense. But I've seen him do things that don't make sense. So I'm kind of like, I'm in fucking limbo right now, but I'm not going to give up. I know that much. I'm not going to give up. And if I lose, I'm going to go down fighting. Because I think that I deserve that. I deserve to put up a fight for myself. And I think that other people who haven't found the strength yet, other people who haven't found an outlet yet to do that, they deserve for me to stick up for them. Like, I'm not backing off of this. I'm not. So let me get Brucey in here. Hang on. Legal vices, I just don't understand legit adults who just enjoy being a bully, making people dislike them. I really can't wrap my head around it. The weirdest thing about this is, like, he does that, right? And it's like baiting. But then when you're like, yeah, I don't like you, he gets mad. And he's like, I'm not a bad guy. I'm like, then don't sue me for $150,000 over non-monetized commentary on your non-monetized video. Like, his video was not even eligible for monetization. Mine was, and I turned it off because I didn't want to hurt the guy's feelings. And he was complaining about it. So I was like, okay, fine. Let me rectify this. Fuck. What a weirdo, man. What a weirdo. And weird people, they don't have to be bad, but the guy's a weirdo, make no mistake. So am I, but not quite on the same plane. All right, Bruce, I'm sending you a link. Toaster Ghost, sorry to hear that. What did Toaster Ghost say? Hang on. I'm in that position right now. I'm being picked on by the bigger guy in a massively horrible, hostile, life-changing, threatening way. I'm having a really tough time fighting them. Oh, I'm sorry. I don't really know what's going on with your situation, but if there's anything I can do, please let me know. Let's see. AKA the cat lady, there's no way you can claim $150K. There are no damages to him at all. I mean, by the time that guy would get a judgment against me, I'd probably be that far in debt. So, like, it doesn't matter. He's not going to see a cent of it. So if he does this, it's just to be an asshole. I want to be very clear about that. If he does this, he knows he will not get any money from me. And he would probably get like $7 if he had my YouTube earnings garnished. So, like, you know, it would just be to be an asshole. Hey, Bruce.
Ladies and gentlemen.
What's going on? Cat Lady Ballerina, thank you for the 5. Runkle is super cool and is always friendly with other content creators. I cannot read right now. God. He flew down from Canada and camped outside the courthouse for the Depp Heard trial. Wow, that's cool. I didn't know that. So I was like, I followed the Depp Heard trial from like social media and stuff, but I didn't really watch it. I don't know why. I think I was just like, I'm so tired and busy. I just don't care enough to watch it. But now I kind of regret that because I'm like, people keep referencing all this stuff that I don't know.
Yeah. Well, I think you can go back and hear on Emily D. Baker's channel. I think she will have in her live stream, or she'll have a playlist, and you can basically watch through the whole thing.
Okay. Cool.
Because I did that with the Murdaugh trial. I watched her live streams for the whole thing.
Yeah.
I was driving up to Seattle a bunch and back, and it was great.
She covered recently. There was this lady, I think it was down in Florida too, where she had left a baby in the hot car, and the baby, died. So I was watching her. That's how I came across her channel, actually. So she's pretty cool. And Tug too. Yes, I know Tug was really big on that Heard stuff. So Legal Bites and Legal Vices. I follow Legal Vices, obviously. Legal Bites, I don't know if I have seen Legal Bites yet. And that's just because I haven't really been around YouTube that much for that long. So.
Yeah, actually for the Johnny Depp case, I think there's so many channels that covered it, the whole thing, from start to finish.
Yeah.
More than other cases.
Troopers Paul Perrette, Debbie Jo A. Oh, wow, that's a long name. Does Florida have anti-SLAPP? Yes, but I don't know law enough to know if that would even apply. Like, I don't know, because isn't that just for defamation suits? I'm not positive. Ask Vices. He's in the chat. Let's see. And then let me just send the link over to Patrick, and I'll pull up the documents here. Hopefully you guys will remember Patrick. I think, Bruce, you were probably on the stream last time Patrick was on.
Oh, yeah.
Cool. All right, let me share the screen real quick because we'll go over the recap of the bar complaint before he hops on. You guys can see all kinds of Reddits that I'm on. I don't care. I'm not embarrassed. Okay. Recap of Gingras reading Mata's bar complaint. And I was going to show screenshots from his YouTube video, but it's just going to be easier to read it this way. But here, since I'm actually not a dick, what I'm going to do is I'm going to share the link to the video, the original video, with you. I know I don't have to do that, but I'm a bigger person. Better person than he is. Probably a bigger person too, man. I don't know. I just ate a lot of pizza. Let's see.
Oh, okay. So he did the bar complaint video after his walking around town video. Is that correct?
Yes. So that I didn't actually see that. Here's the link to David's channel. Do I think that you should follow David? It depends on whether or not he's going to be a dick and sue me. If he's going to sue me, no. If he doesn't sue me, maybe make up your own mind. You know. But I am going to put the link there, just because I'm a decent human being, and I don't try to rip off people's work. So, yeah. All right. Hi everyone, I have a way of watching a YouTube video about getting views, blah, blah, blah. Okay. So, DG has found a new way to make coming up sound deeply annoying. What does that mean? Did you watch it, Bruce?
No, I haven't had time to watch it. Also, he kind of creeps me out, so I don't...
I mean, he didn't really creep me out. Like, I was like, kind of like, oh, he's almost a little bit charming. And then he was like, I'm going to sue you for $150,000. Happy birthday, bitch. So now I think he's a little creepy too, but
I think after talking with Dave a little bit and revisiting all the things he's done over the course of this case and refreshing my memory on all that, plus everything else that's happened since his first YouTube video.
Yeah.
I'm just, it's not something I'm interested in.
Oh, absolutely. And the fact that I'm still here batting hard to be like I'm on the fence type of person, and just like, I can't believe that he is suing me.
Yeah. I mean, I still enjoy, court filings and court documents and all of this.
Yeah, let me try to...
Just in terms of, whatever this person is talking about here, where he's like, oh, coming up, I'm going to do this, that, the other thing, right? He said he had a video on deck about Mike.
Yeah, so that's where actually things went wrong between me and David, whether he knew it or not, was when he started tweeting about Mike and he posted that stuff about Mike and his past relationship with Laura. That's when I was like, I do not like you. I think you're a bad person. So, and I've teetered back and forth since then. But at the end of the day, if he were to publish that video about Mike, I would probably go scorched earth and never look back. So I don't know. I get really protective of people really easily, and it is not okay for Mike Marraccini to have suffered the kind of abuse he did. And there is evidence of that. That's not speculation. It's not conjecture. There's no reason for Mike Marraccini to have suffered what he went through, and for David to poke at him for it and say like, oh, the guy didn't have it that bad. He went to Dubai or whatever. I'm like, yeah, dude, I went to Austria with an ex who faked cancer, and she was an abusive piece of shit. Okay. It didn't take away from the fact that she was abusive.
Yeah.
So, I don't know. That's when the guy grossed me out, and that's why I have such a hard time with him. So
yeah. There's a phrase in the music industry or the recording studio industry: you can't polish a turd. So if someone is abusing you, it doesn't matter if they're showering you with gifts and trips and all this other stuff. They're still abusing you.
And I think some people like in this position, my opinion of David at that point was, like, he will try to make him feel bad for being showered with gifts, even though it was a fake Rolex. You know what I mean? Like, he will try to make him feel bad for taking trips that he was basically like forced to go on with her. And like, he was not a happy guy. You can tell by the messages he sent. Like, he was not happy.
Yeah.
And so to say that he had it fine, like,
I mean,
wow.
My impression is, out of all of these men, with Clayton and Greg and Mike and Dave and whoever else, Mike is like the most mild-mannered, calmest, nicest guy of the bunch.
And I'm sure you would agree. That's not to say anything bad about the other guys. It's just to say, like, Mike is so, like, he's such a sweet guy.
Yeah.
So, and I feel like, I know he'll probably be like, you don't know him like Laura does or whatever, but I know him enough, I know enough. And I know enough about being on the other end of that kind of abuse to know that what he's been through was not okay. And that never
we can watch these interviews and everything and read the transcripts of the text messages and, the interview on Megan Fox's channel. Trust your instincts,
Right. Okay. DG apparently shot a video with Ella, but there was no audio, so no posting that. What does that mean? Okay.
Maybe they tried to do a video and the audio
it just ended up being faces or something. They could make it like a NFL like bad lip reading or whatever.
Yeah, some of these cameras, depending on how they're set up, they won't do audio because they're assuming you're recording audio through a separate recorder or through a separate input or something like that. So.
Erica says Mike is sweet, Greg is hilarious, Clayton is muscular. Agree with all those assessments, but I also want to point out
it's like
the
Disney
entire
characters.
Which one is Gaston?
Right? Yeah.
Yeah. No, I also just want to point out, like, Clayton, the whole reason I got involved in this in the first place is Clayton is a really nice guy who did me a favor. And I don't know Clayton, like, super well on a personal level. We just met on June 10th. He was very nice and kind, and we talked about, the stuff he said to me and just, like, random stuff. I was just like, I just want to talk to you about random stuff. So he was a really nice guy, and I liked him a lot. And I think that I hate the way that he's being slandered constantly with this, especially with, like, it's about fame or all that, because what Clayton did for me, he did it, 1, for free, 2, behind closed doors. Like, nobody would have ever known that he did what he did. And it was a big deal to me. So, yeah. King Salmons, thank you for the 5. Ron Owens purchased 500 followers for Dongus. I honestly, the thought crossed my mind. I'm not gonna lie to you that maybe they were purchased. Hey, Patrick. What's up?
Hey.
The thought crossed my mind that some of the followers may have been purchased, but the truth is, I don't know.
Yeah. Prove it.
Yeah. We were just going over the recap of this bar complaint before we get to the appeal. Have you read this, Patrick?
Which bar complaint?
Mata's. It's a recap of Mata's bar complaint.
This is Judge Mata's bar complaint against David S. Gingras, Esquire.
I hadn't gone through the whole thing now.
Yeah. I have not either. Let's see. DG talks about a DM he received from Anya, and that was the person that he said asked a question to them.
Okay.
Talking about how he needed to do better by Laura and compliments the DM. David complimented her DM. Okay.
The message, yeah.
David, DM and DG is confusing me. David states that he appreciates everyone who shares their opinions and views and wants to help everyone understand what's going on. Well, then by all means, sue me for more than I'm worth.
Oh, dear.
My God, dude. I'm sorry. I'm never going to, I hope this doesn't go anywhere, but regardless of whether or not it does, I'm never going to let the jokes go, man. Never. Because that was actually really stressful to, get that kind of threat and that on my fucking birthday of all places, you know what I mean? David states the facts of the case are almost irrelevant to the court's job and stands by this belief. David states he can't get into the facts in the Court of Appeals, just wants them to do the right thing legally. Patrick, what is your thought on that line right there?
Wait, can you read that back to me? What does he say?
So we're reading right here.
Top item.
David states the facts of the case are almost irrelevant to the court's job and stands by this belief. David states he can't get into the facts in the Court of Appeals, just wants them to do the right thing legally.
The facts of the bar complaint?
No, so he's talking about the appeal here, but the rest of it's going to be about the bar complaint. So it's just kind of a recap of his entire life. So
he jumps around a little bit.
Oh yeah. Oh, I did listen to his little thing. Yeah. I think he just picks and chooses when he doesn't have something smart to say and then just says, "Oh, I'll get to it later."
Mm-hmm.
But I don't think anything is irrelevant when it comes to your law license. So
yeah,
I have personally.
What about the appeal? His appeal action.
The appeal in terms of being relevant to the complaint, to the bar complaints. No, I mean, unless
no. Just the appeal on the face of the appeal. He's basically saying, I don't need to talk about the facts of the original case in my appeal motion because they're almost irrelevant because the court is really looking at matters of law, not matters of fact. I think that's his point.
Yeah. Oh, and in that case, I agreed and disagreed very lawyerish. The fact that he tried to have Mata removed and then the presiding judge said you're relying on conjecture and that's why it's we're not going to remove Mata because the standard of review for structural error is de novo, which means they look at everything new. I don't think it's a fact he would want to put in his case, in his appeal brief, but Clayton may want to put it in his appeal brief to say, even if this Planned Parenthood thing was an error, it was a harmless error. Whereas David's not going to want to say, oh, and by the way, another judge also found that this was harmless error. Like, I need you to focus on my on what I'm saying. And I think that's like a big part of an appeal, is that it's still advocacy. I mean, it's more formal, but you're still advocating for your position.
I think it's just a weird way to phrase it, because to me, linguistically, when you say something is almost irrelevant, that implies it's still relevant.
Well, it's relevant to the extent that she wasn't removed from the case. That seems pretty relevant.
Yeah. Well, he doesn't get into the details of what specifically, it's like I'd rather see this stated in a more direct way rather than in a more passive, indirect way, if that makes sense from a language perspective.
Yeah, or just
But
like what he's really good
I'm not a
at.
lawyer, so
He's really good at not having a because after some of his declarative statements.
Yeah.
Sheebs, Ron wrote like 5+ responses to each individual. What page? Send me a link to that.
Is that Facebook or something?
It must be. I guess Mary Lincoln's might be checking on him. I don't know. Okay. David states that he can't let Laura speak on items the county attorney will look into until Rachel Mitchell closes the case, which I find curious because the other day I was sent an email from David where, as you guys probably watch this and know, like, he admitted that Laura was never told by a doctor that she was having boy-girl twins. So I'm like, but so she can't speak on it, but you can? Like, what? I'm confused by that. I'm not trying to be a dick. I'm really confused by that.
Yeah, that's a good question. As her lawyer, if let's say he just stops her from talking to anybody, which, by the way, he didn't. He brought her onto his channel. But let's say he did stop her from talking to anybody or making Medium posts or whatever. Right. If he continues to talk about the case, is that just as bad legally while there's an investigation going? This is my question.
I really think that he is flirting with becoming a witness in a criminal case. I think if it gets sent back down, he might be a witness in the civil case. But I also read this statement as a reversal of their position from Podcast Gate, where she would have obviously spoken on things, and maybe cooler heads did prevail, and it was like, okay, we're getting too close to things that the county attorney may be investigating. Let's scrap this whole interview. And he shut her down pretty quickly on everything that she was trying to talk about. The only question was like, I can't even remember. Megan was laughing about it.
It was, how is she feeling? Is she okay?
Oh yeah.
Yeah. So I think this is a reversal of position from where he was originally at when they were in the podcast studio. Like that 2-minute video where called himself whatever and called her pregnancy faker, and she said yup. I commented that just her saying yup, like, it may be sarcastic, it may have been a joke, but that's an admission.
Yeah.
In a criminal case, and you just stack those coins of admissions, and
I thought that was very inadvisable to do all that.
Bad.
Yeah.
So I think that's why there's
I'm wondering if anything from the podcast studio ends up in her Patreon. Because she's going to do that now. So,
I mean, there's nothing to stop county attorney investigators from joining her Patreon.
Oh no, I'm just saying. I wonder if she's actually going to do that. If she's actually going to use that footage or that recording. Like, I don't.
Or she could make her own new recordings, right?
Yeah, for sure. I don't know if that would be advisable, but yeah.
Oh, absolutely not. No.
No. God. She's going to pull a Corey on David. All right, let's see what's next. Oh, right. Yeah, okay. David says he's not trying to fight with YouTubers on copyright law. Sure, say that to Lauren Neidigh. Hi, David. States it's not fair use for people to watch his videos without giving him views. Lauren gave you the view and even told people they could check out your video. He refuses to acknowledge that, by the way.
I mean, if somebody ripped his video and just put it on their channel unaltered and just replayed it, then he would have a case.
Right. Yeah.
but I don't think anybody's done that.
Nope. I know. Yeah. I was talking so much, people were complaining about how much I was talking over it. So I know I transformed it enough.
And if somebody wants to do that, go rip his video and put it on a different channel unaltered. Please don't.
Yeah, no, we don't want that.
Yeah.
Nobody wants that. Nobody asked for that. You know, like none of us said do this. You know what I mean? But like you're suing the wrong person. Yeah. All right. Thank you for whoever wrote this nice recap, because that sums that up nicely. David notes that people seem very interested in the bar complaint from Judge Mata, and he decided to share the complaint in a show of good faith. Show of good faith would be not suing me. He has already sent a response to the bar, a very long response that he is not going to share. Okay, that's fine. David claims this was his birthday present from her. I guess the bar complaint was sent on his birthday. Well, David, I got to tell you, I don't have a lot of sympathy for you there, because you sent me a false copyright claim on my birthday. All right. The first line of Mata's complaint was, the case has substantial media and social media attention. David ponders how she knew that. Are you joking? David, Mata has eyes. She saw everyone milling about it, including people streaming the case and reporting about it outside later. And she probably saw the articles published after her ruling. And not to mention, like, didn't Corey mention how much like attention it was getting because they were trying to get the record sealed or something?
Oh yeah, they had prior hearings where they were bringing up the publicity quite a bit.
Because they were saying she was being harassed and stuff.
Yeah, so that was the February hearing. You can go back and listen to that, and they discuss it quite a bit, actually, because they're very concerned about if there's any confidential medical information that they need to seal, and they talk about it there. So it was very clear, like from February, the judge knew the context of this case.
Right. Also, I know that Greg Woodnick at some point during his questioning of Clayton said, "You're the bachelor, that's why everyone's here, that's why everyone's paying attention." So like, it's not surprising that she knows, you know?
Yeah.
So, okay, let's see. David nitpicks that it wasn't a trial but an evidentiary hearing. David claims that he never asked for security detail. States he asked for a hearing to discuss the Marraccini presence, and then states that Mata denied it with no explanation. David tried to hire his own security, but the Maricopa court system did not want that and provided their own security detail. Claims that the way Mata words this item in her bar complaint sounds deceptive. And then the person who wrote this says, David, do you think everyone is just out to get you and Laura, don't you? It kind of seems that way, to be honest, especially when he lumps everyone together the way that he does. Like me and Bruce, and I'm sure Patrick too, like we all have different thoughts and opinions on things. Like you got to stop that shit. So I didn't hear that though about his own security. I thought, didn't they have a security guard with him? I thought he was saying in the video that he copyright struck me on that he had his own security guard. Didn't they have that guy with them?
They may have had a bodyguard, from my understanding.
Okay. Yeah.
I'm not 100% on that, but I wouldn't be surprised. And if you can do it, it's not a bad idea, I suppose, because, you know, I think it's inadvisable for an attorney to bring weaponry to the courthouse parking lot.
Huh.
I don't know.
Yeah.
It's just a crazy notion.
Right. Patrick, this is a random question. Have you ever seen somebody or like known a lawyer who's been given a bar complaint by a sitting judge?
No.
Okay. You've never heard of that, or like anyone who, you know, had that problem, or?
Yeah, I think maybe not necessarily a bar complaint, but referrals to the state bar.
Okay.
I think that's probably more common.
I don't know the difference. Can you explain?
Referring is more, I guess, is less involved than actually sitting down and putting pen to paper to write out what the actual issues are. Referring the case to the bar would just be simply notifying the bar that this case, you know, involved these parties, and the bar can take action from there, as opposed to being, you know, specific things that they have issues with.
Okay.
All right. Okay, let's see. While Mata states that Marraccini and Laura were kept an appropriate distance from each other, David begs to differ because the OOP states that he should have been 300 feet from Laura Owens. I mean, there were not a million people, there were like 10 or 20 people between them, so I think that was enough distance. Mata states that David called 911 from the parking lot, attempting to get Mike arrested. He stated that this is inaccurate and that he called from the building. And then the person says, lovely nitpicking here. Again, the guys, the parentheses, they're not my comments, but I don't disagree with them. Okay.
Yeah, I mean, sometimes, I've worked in corporate America. Sometimes when you say building, it's inclusive of the parking lot and the actual office building.
Mm-hmm.
Because you're really talking about the entire private property of the company or something like that. So I don't know. This is very nitpicky to me.
Right. It was outside the courtroom. I mean, Stephanie says, didn't they decline the need for Mike to wait in another room? Yes, they did. Because they didn't want Laura's mom to have to wait in another room. So, yeah. So if he was really that dangerous, I'm sure they would have taken the court up on that. Okay, let's see.
Yeah.
David claims because Mata didn't allow the hearing to discuss Mike's presence, he should not have been permitted to violate the OOP. He also claims that he was told to call 911 by the court security, that Phoenix PD had to come via a 911 call. He also claims that Mata's clerk said that if anyone felt threatened or endangered, they could call 911. But here's the thing. When and why did you feel threatened or endangered? Like, that man was just trying to stay away from you. So...
Yeah, it's weird. He didn't ask the clerk to call 911. He did it himself. The other thing that I think is interesting here is he calls it a violation of the OOP. If there is an exception to the OOP because of a subpoena, that is an exception, not a violation. These are two different things.
Yeah. Okay, let's see. David also claims that when Woodnick walked in, he tried to talk to him, saying that Marraccini could testify, but not within 300 feet of Laura, i.e. have Laura leave the room while Marraccini testified. Seeing all the evidence of how David threatened Mike / witness intimidation, this version of events does not seem credible. Hey, David, you're just like, hello. So, okay. So, I don't really see how that would have come to play. So, like, all he would have to do then was like take them up on that rule, right? Where the witnesses, Greg and Mike and Laura's mother or whatever, would have to wait outside.
Mm-hmm.
The sequestration rule.
What's that?
Yeah.
Sequestration, where you're asked to sequester the witnesses.
Yes.
I don't know what that means.
I was telling you.
It's an option.
I thought you were asking. I was like, dude, I don't know if you don't know.
It's
what do you think?
In high school, they took us down to the county courthouse in the capital, or in the city of Madison, Wisconsin, and they just wanted us to see some court, the court system in action, right? Civics. And there was a courtroom that a few of us walked into, and the bailiff was like, "If you are a witness, you can't be in the gallery." So, there was a case where that was happening.
Mm-hmm. And I will tell you this. I was standing in the line, like right at the door, about to go through security, when Laura and her mother and presumably David, I didn't see him, but I wasn't really looking, went through the door to go through security. No one said anything to them. No one heckled them. I know Mike and Greg were probably nearby at that point. I know Greg was, at least, and nobody said anything to them. I was extremely conscious of like my behavior around them. I did not want to make them feel uncomfortable. That was not my place. You know what I mean? Like I didn't go there to do that. So I don't know. This stuff just really bothers me that they're saying all this crap about Mike. I'm just like, Mike was the perfect gentleman. Like he did not do anything wrong. So.
Yeah, when I rewatched the court case, I actually saw that it was like Mike's significant other. It was you, Mike's significant other. Oh, sorry. You, Greg's significant other, Greg, Mike's significant other, Mike.
Right.
And then in front of them was Clayton's family. Like they couldn't have been any further away from the aisle.
Mm-hmm. They're around the end. Yep. Okay, let's see. David claims that Woodnick wouldn't speak to him, and that was very unprofessional of Woodnick, and that Laura was demanding something be done to protect her. And then so he says, what, the court security wasn't enough. So, yeah, they had their own bodyguard, and they had the court security, and, like, literally those guys want nothing more than to stay away from her. So, like,
and didn't they wait in a special room instead of waiting in the hallway?
They waited in I think it was the maternity room, which was hilarious.
Oh, dear.
Because she was never pregnant. Sorry.
Irony.
Yeah. Okay. David claims Woodnick attached the subpoena to some 70-page document, so David didn't know about it? What? And then the person who wrote this summary says, so you didn't read the documents in entirety. That's not a good confession, and that's a public on your part.
Yeah. I mean, yeah, an appeal to ignorance is usually not a good approach.
Yeah.
If it happened before his time, he has no idea what we're talking about.
I mean, the way he just like stood up and said that, I was just like, that was a bad idea, right? I was just sitting there like, Scott, was that a bad idea?
It was not a good look. Wasn't a good look.
I actually, maybe because we didn't see it on camera, but had blocked out that he had Laura do like a twirl on the stand. Can you tell us, Lauren, like what was that like?
So it was obviously I was really focused on the stream and like making sure it wasn't like cutting out. But I remember her standing up and doing the like twirl or whatever, and I was just like, why did she just do that? What was the point of that? And I guess they were trying to show that she had lost weight or something. But then now she comes out with this article about how she ate Domino's pizza every day for 6 months and then stopped. So like kind of the math is not mathing a whole lot right now.
Were you able to pick up anything like on her mannerisms, like nervous, not nervous?
Yeah, especially when she, got to the point where she's like, "That's not fair" to the yes or no questions. It was like, "Oh God, you're dead in your tracks right now."
I mean, he asked her how she was, and she said nervous, and I think maybe that was one of the correct answers she gave.
That did not tip me off.
I mean, yeah, the twirl was weird because it seems like they're trying to. There's sort of this idea in debate that if you have this large collection of bad evidence, it doesn't mean that you get to infer that you have a good conclusion or that you have like one good evidence, right? The sum of a bunch of bad evidence is not a good evidence. So when they have these anecdotes like twirl around, you look thin. Oh, you weren't thin before. Maybe you were pregnant.
God, nobody ever tells me to do that.
This isn't good evidence. This is just like compiling or integrating a bunch of bad evidence.
Everyone in the chat, Sentinel Ninja has joined us.
Hey, apologies to those who are not happy about that announcement.
Why?
What?
Hey.
I got some haters, guys, in case you didn't know, which I think you do, but
I mean,
anyway.
So do I, though. Like, I mean, one of them's trying to sue me for 6 figures. So
what?
I feel like I've been hanging out with you all day, Schnitzel. I listened to your reading of the appeal.
I'm sorry.
Like,
while you talk about that, I'm just gonna. Erica asked for a twirl, so.
Oh.
Ooh. Wait, I'm doing one too.
Oh boy. Yeah. I mean, that's how to get the haters off your back.
Oh yeah.
Oh, there it is.
Can you twerk and twirl?
Oh no.
You'd have to pay me for that.
Well, I sent you condoms, so.
Yeah, but
we already saw the microphone in her butt.
In California, so.
You didn't bring them with you?
No, I did not bring them with me because I wasn't gonna fuck any dudes on my trip.
Oh man, sorry, I'm a bourbon in.
Oh, you know what?
I've got another one.
I'm gonna pour a very bad cheap vodka, and Omar would be there just pointing me right now. But
on behalf of all the men on the West Coast, I'm disappointed.
All right. So he also claims that Arizona subpoena does not have merit outside of Arizona, so it couldn't be valid in California. Huh?
Wait, what? Can you highlight what sentence you're reading?
Yeah, right.
Yeah, this is fresh off the press.
Yeah.
What? Though, like, because the court case was in Arizona. What do you mean it wasn't that? What?
I'm double checking. I think that's wrong. Which surprise, right? Surprise.
An Arizona subpoena can't subpoena a California witness. Interesting. I don't know.
That's not true, is it?
I mean, it's more double talk because then he's saying that a California restraining order should be enforceable in Arizona because of the Full Faith and Credit Act, but the Full Faith and Credit Act would also make the Arizona subpoena apply in California.
I see. So he hasn't explained why one would apply but the other would not.
Right. Which I'm waiting for the appeal to get into like why I think that is his whole personality.
Also, like I'm
That's a mic
thinking,
drop.
do we have more trust in Woodnick or do we have more trust in Gingras? And if we have, which answer is A, Woodnick, we have more trust in him. Do we think he would do something that was illegal or not allowed, like trying to subpoena a witness from another state? That's fucking bullshit. How is that you?
Well, we don't know that anybody's doing anything nefarious. It could just be, these things are interpretive, right? Like, so you could just have the wrong interpretation and not be doing anything nefarious.
But wait, if I wanted to subpoena Amazon for records, I would have to send that subpoena to wherever Amazon is headquartered,
Right.
which wouldn't be probably, just assuming it's not here.
Mhm.
And they still have to, this is the thing about subpoenas is like my unofficial legal advice is if you ever get one, throw it in the trash until you get compelled. But the subpoena is really just a document written by an officer of the court telling you to do something. There's no actual enforcement mechanism for it until you get to contempt.
You said until you're compelled. What is the mechanism of compulsion?
Yeah, so we almost saw it with the deposition situation. Same thing for subpoenas. You issue the subpoena, the person ignores it. You typically you send them a couple more, and then you'd file something in court, holding that person in contempt. That person would have to receive notice and then appear.
Notice of what? What is this notice?
Of the contempt proceeding.
Okay.
So then they'd have to receive notice of the contempt proceeding, and then they would have to appear or not appear. Assuming that they don't appear, then they would be held in contempt, and then you could have the sheriff's office. You'd have to give the sheriff's office that order, and they could then execute.
Okay.
That the judge.
So if you get a subpoena, you can ignore it. If you get a notice of contempt, and you go do whatever the subpoena wanted you to do, are you in good shape?
Yes, better off than if you didn't do anything.
Yeah. Okay, I think I understand the process. That's very helpful.
That's what happened to like Peter Navarro.
I mean, I hope it's not helpful for me in any point in my life, but it's very good to know.
I learned recently the only subpoena you don't throw in the trash are congressional ones. Those are a bigger deal.
Oh, Congress. Well, they're on C-SPAN and stuff. I mean, you can't ignore those.
I wish you could.
Omar would be so disappointed in me right now, but I did pour a nasty glass of cheap vodka in here. So.
Just plug your nose and swallow.
Yeah. You have to make concessions when you're traveling,
Yeah, I was working though, and so I was like, I don't have time to like go to a store or anything. So I was like, okay, what's the closest and cheapest thing that they have here?
What's the brand?
I don't know. I thought it was New Amsterdam. Hang on, no, it's not New Amsterdam.
Kirkland vodka.
It's not Kirkland vodka. I know. I can't really see. It's in my trash can over there. They were airplane bottles.
Oh, okay.
I can't really see them.
That's funny.
I'll text you after I go through my.
Oh my god! Can I tell a quick story?
Yeah, go ahead.
I was flying to England with my mom this one time, and this was like 11 years ago, while ago. Anyway, Natus, he's like, fuck that story.
Brutal.
So we got Comfort Plus seats, and it was like when Comfort Plus was like pretty new, or at least it was new to us. So anyway, it was very exciting. You got free alcohol. And so we had red wine first. And my mom, she doesn't drink. I don't drink a lot, but I drink like more than my mom. She doesn't really drink at all, but she drank some wine and then said, I can't finish it. Then she got some Baileys and cream for some reason. She thought, anyway, so she drank that. I drank like 2 or 3 bourbon bottles, the little bottles of bourbon after having her wine and my wine. And, in the air, it affects you like more quickly. And so my mom is on the inside. She gets up to go use the bathroom. And when she woke me up, I was like, "Ooh, I don't feel so hot." And so I fell back asleep. She came back a while later. Not going to tell you what she did in the bathroom, but when she came back, she woke me up again. I then again like felt even worse, and then she proceeds to tell me what happens in the bathroom, which made me also sick. And I in the dark, I reached into the back seat pocket. I somehow immediately grabbed the puke bag and I silently retched into this bag because I didn't want to wake anyone up. And I was so embarrassed. I did it as quietly as I could. And then I went, took care of it all. And then I was passed out. I didn't even have breakfast. It was, anyway, your airplane alcohol bottle made me think
You're
of this
getting
story.
two very different reactions to the story. One is Bruce, that's disgusting.
I
And
know.
one is me, yeah, I've totally done that.
Oh man, it was I will never forget that trip.
It was so gross.
It was not my best moment.
All right, let's see. David claims that Mata asking the police not to detain Mike was improper and unlawful, and states that he explained to the bar in his response, cites a federal statute that requires you to honor court orders from other jurisdictions. States that Mata did not honor the order, but also instructed police not to enforce it, says that is extraordinary. This doesn't make sense, though, because in every family court case involving domestic violence ever, isn't this a thing? A witness with a restraining order might have to...
Yeah. Also, I'm a little confused about how he's saying that the judge asked the police to do something. I'm a little skeptical that direct communication ever even happened. The other thing is, if I was the police and I thought I had a legitimate reason to arrest someone, I don't know if I would listen to a family court judge while arresting the person. I would just do my duty as an officer of the peace and execute my job. So I feel like the police came to their own conclusion, regardless of whether the judge spoke to them or not. So I find that very confusing. But I don't know. Maybe all this happened. I just don't know. We don't have, GoPro footage to, piece together the story. It's just there's the story in, I guess, this bar complaint. There's David's commentary about what he thinks happened. Beyond that, I don't know that we know too much.
I have a take on that Arizona subpoena thing. So I'm gonna paraphrase what my friend said. It's dumb. You don't need a subpoena to come to court. It's not a requirement to testify. It just orders people to go when they otherwise may not show. So if they don't show, it can be the basis to force them to show and not hold in contempt. That is mentioned. Most people don't even get subpoenas. They just show because they're asked to. An Arizona subpoena may need to be domesticated in another state to enforce it there. So that and also I wanted to point out that the court already had ruled on his motion in limine that was attempting to preclude Mike and Greg's testimony. So Gingras knew for forever. It was in April, I think. So at least 2 months ahead of time that they were coming.
That constitutes an emergency.
Right. Yeah. And also that morning, Gingras was not pleasant about the whole police situation. He was a total and utter fucking asshole, in my opinion. Dealing with it and swearing at people, swearing at Woodnick, swearing around when he saw Mike in there. It was not from what I hear, it was not pretty.
Not cordial.
Yeah. Nathan says people on Twitter told David that the subpoena wasn't a filing, and he was like, huh?
I recall that, yeah.
As an ADHD person, I get it. It's hard to read long time.
And don't be a fucking lawyer.
Yeah.
Well, now, subpoena or no, if Mike is on the list and the motion in limine is turned down or whatever, and he's on the witness list and he shows up, even if there's no subpoena, just being on court property, doesn't that override the order of protection?
Yes. Yes, it does. Legally, it does. He's going to argue that it doesn't.
I mean, you're not really in the normal public. You're in sort of state or federal space.
Right.
At that
And
point.
I will say that Mike was chaperoned the entire time he was there, from the time he got out of his Uber or Lyft, don't judge, I'm not sure which one he used, to the time he got back in to another one of those.
Chaperoned by who? Sorry?
Well, his wife and another individual.
Okay.
Who
but
was
not like a police officer or something.
No, people who saw shit, people who witnessed it and could see. I mean, like, so she couldn't try to.
Well, I see. There were eyes on him at all times, is what
exactly,
you're saying.
And specifically, so she could not claim something happened.
Yeah.
Let me catch up on these real quick. AKA the cat lady, thank you for the 5. As Tug said, someone changed a title but posted the original video unaltered, and that was still transformative. It's in the case law. Tug did actually send me that, or Tug did actually wow, Lauren. Tug did actually send me that. I've had half a drink. Tug did actually send me that, and so I appreciate that. I'm gonna mention that in my little counterclaim. Karen Carson, thank you for the 5. DG likes to copycat what everyone does, repeats things like they came from him. Look, Daddy, I'm a real YouTuber. Oh man, not my words. Not
his YouTube career was a hard launch.
Fake Laura Owens, thank you for the 5. How does Gingras not know he's primed for a SLAPP case? I don't know about that. Patrick, do you know anything about like an anti-SLAPP? Is that just for defamation suits, or how does that work?
I had a question about it on the bar, which I also passed the first time. But I don't remember it.
Nice.
At least he's honest. Yeah.
Something about speech. You can't be retaliated against for speech, but I'm not sure if it has to be like political speech. I don't know.
Well, I mean, this is copyright, so I don't know if it really applies. Even though the copyright was premeditated and used as a means to stop someone from commenting on something. Clearly, because he said any part of this video, I will sue all JFC YouTubers. So like that's pretty, but I don't know if it really applies to SLAPP suits. I don't know. I think you.
I imagine it does. We looked at it pretty hard when Dave was embroiled in his legal proceedings.
Mm-hmm. If they came after me for defamation, that would be a different story, I think. Let's see, Loud Little Ducky, and I believe that's why he didn't call my bluff before when he said he was going to sue anyone who said this, and I was like, okay, well, I'm saying it because this is what happened. But they can't do that because that would open his client up to discovery and also anti-SLAPP suit. Loud Little Ducky, thank you for the 5. You might be pregnant from Tragic Mike. Should have brought your protection. Guys, if you missed that thread, Tragic Mike was a dancer on the river cruise I was on last night in Sydney. They had like these fancy ass dances, and I went on this boat alone, right? Because my friend got sick, and so I was at this little table alone, and the dancers kept getting real close to me and stuff. One of these guys at some point takes his shirt off, and he's like running around. But then one of the songs got really somber, and so he wasn't Magic Mike, he was Tragic Mike. So yeah. King Salmon, thank you for the 2. We did bring Patrick back, so Patrick is back. King Salmon, thank you for the 5. Patrick, don't leave us.
Oh my God! All right,
Lord,
King.
go back down. Tweaker boy.
I got some anti-SLAPP info for you. Sorry, I don't want to interrupt. Cool. So in Arizona, it allows you to file a motion to dismiss if you're sued for something and you were sued for doing something that was free speech or freedom of press or the right to freely associate. So the way that would play out would be you'd receive a copyright complaint, your service of a copyright complaint, and before you even answered the complaint, you would file a motion to dismiss based on the anti-SLAPP statute. So it would actually be before you even answered the complaint that you would try to get it moved. But that's, when you're defending yourself, you want to use as many defenses as possible. So it'd probably just be one of many.
Gotcha.
Nice.
All right. So I'm confused also as to like whether I'd fall under Arizona jurisdiction because I'm in Florida. So how would that work?
So there's something called a long arm statute, which allows federal courts to get jurisdiction over people in other states. And there are some requirements for it. I think the question would be, where did the alleged infringement, where did the fair use occur? And I believe it would have occurred in, again, so this is something that if you were served with a complaint, you'd file a motion to dismiss for lack of personal jurisdiction.
Yeah.
And in addition to the anti-SLAPP, and the court would need to make a determination about whether or not their long arm statute could get personal jurisdiction over you.
Yes, and people in the comments are saying it's correct. I was in Australia when this happened, so I don't even know. I mean,
oh, you were in Arizona, yeah, or you were?
No, I was in Australia. I was not even in the country, but there's like some laws there that extend to the U.S. And where they can prosecute for crimes committed on Australian soil or something. People were telling me, and I don't really know, but because this isn't like a crime thing, like I don't really know what's going on with that. But that's why I'm so confused, though, because I've been all over the place. Like right now, I'm in California. So.
Well, one of the parts of the long arm statute is like, based on the equities of the party, is it fair to force that person to litigate in Arizona? And I think you win that one all day. But another thing to just nerd out a little bit is, where, if the video is uploaded to YouTube, where is that server being housed?
Oceania.
Probably, yeah. You guys should go to Guam, litigate in Guam.
Yeah.
Can you imagine? Oh my god.
Again, these are just things. Yeah, these are just things that you would just file a motion to dismiss. You already have two amazing. Personal jurisdiction is one of the most powerful weapons and shields and swords that we have in civil law, civil litigation.
Yeah. Well, I hope I don't have to find out, but if I do, then I'm sure we'll learn lots of stuff. Okay. All right, let me try to get back on track here because we. All right. Did we read this about believes he was trying to prevent Mike from testifying?
No, we didn't see that one yet.
Okay. Mata states in her complaint she believes David was trying to prevent Mike from testifying. David claims this was a baseless accusation and not even close to the truth because Mata didn't talk to him about it. Mata states that David was signaling to his client with sweeping arm movements during Laura's cross-examination and says that she interpreted this as to prompt certain responses. David muses, what responses did she think I was trying to prompt?
All the fucking answers. Literally all the answers. David
states that he was not coaching Laura. I don't even know what that means. Okay, well that right there is like, obviously you know what that means. So saying I don't even know what that means is like not helping with the credibility aspect. I'm just trying to give some constructive criticism here. I'm not trying to be a dick.
A little disingenuous.
Yeah. States that Mata was looking right at him. So states that if she saw any coaching, then wouldn't she rule adversely to David? Well, I mean, didn't Deandra go stand in front of him? So it wasn't like necessary.
Yeah.
Oh God, no. This is why I can't stand him, dude. Even now I'm trying to be nice to him. And then of course he has to attack Deandra. And I'm like, I love Deandra. Don't do that. David is deeply insulting towards Deandra, claims she threw out a childish line and imitates her in a high-pitched nasal voice. First of all, Mr. Gingras, she does not have a high-pitched nasally voice. I would like her to yell at me in her deep, powerful voice. Thank you very much. And then he says, Your Honor, looks like he's trying to coach, when in reality, David was trying to tell Laura to stop because Deandra was interrupting Laura on the stand. And the court reporter stopped the testimony and stated that she couldn't hear them talking over each other. David states that he had the same thought because of the bad ring in his ear. Also, David, this is the second time you're displaying misogynistic behavior towards an accomplished woman. Is this a trend you want to continue? And that was, I believe that was from the Redditor, not from Judge Mata. I do not like him coming for Deandra like that. Like she's like, I like Deandra. Okay. I've never met Deandra. I like Deandra.
Yeah, this seems to be more of a recap of his commentary on the bar complaint rather than a recap of the bar complaint.
Right. David stated that he found Deandra rude and pushy. Well, that's when a lady talks over you, I guess that's what some guys call it. But there's
or
a
when
reason
she's
for that.
hired to
to do a fucking job.
Yeah.
And that she kept interrupting the witness. Well, yeah, because the witness wouldn't even answer a yes or no question.
And Mata even had to threaten the witness and say, like, this is going to go down a road none of us want this to go down. So, answer the fucking questions, bitch.
Yeah, the judge was admonishing the witness more than the attorney.
Yes.
Okay. She claims Mata didn't have the courtesy of asking him if there was an issue. Wait, why would she ask if there was an issue? Don't you have to object?
Right.
Or something? Okay. David claims that if Mata asked him about the coaching, he would say that Deandra was speaking over his client and that he and the court reporter wouldn't be able to process 2 auditory inputs at once. But I thought you said it was because of your hearing issue. So, like, which one is it? Is the thing. Mm-hmm. That's the thing.
He does this all the time. He contradicts himself. Like,
is it auditory processing or is it hearing? Or is it both? Mm-hmm.
Good Lord. Okay. Mata states the court issued a ruling on June 18th, but David sent an email on June 17th. David claims that Woodnick emailed the clerk numerous times and states that in a normal civil court, you don't normally do that. So he emailed the clerk as well, addressing not Mata, but Judge Mata's division, asking various questions of Mata, asked whether her father was there. Well, could that be because there were accusations being made? I don't know. Stating that these questions were ethically required because he was hearing things from JFC and needed to know if they were lying or not. I don't think that's probably not what he said, but okay.
This is when you hire an investigator. When you have a real law firm, you don't do your own shit. You hire an investigator who is detached and objective and doesn't freak everyone out.
Claims that these questions were him trying to understand the situation rather than rushing a judgment like he claims Mata did to him. Okay. I don't know. This whole paragraph here is just a little sus to me, but okay. Mata states that litigation by email, his questioning and needing answers by 5 p.m., is inappropriate. Well, yeah. David states that this is not litigation by email, but him complying with his ethical duties to investigate misconduct by a judge before claiming misconduct by a judge. And the Redditor says, David, please comply with your ethical responsibility by looking at the actions of your client. Okay. Mata states that she took no issue with the notice to change judges, which David construes as she didn't dispute the allegations in the notice, which of course she wouldn't because Fisk already disputed those and found them baseless. He states that she took issue with the daddy comment. Of course she did. Of course she did.
Oh my God.
Can you imagine saying that? Like, oh my God. David takes dispute with litigation by email, claiming that Woodnick also directly communicated with the clerk. However, he fails to take into account the subject of Woodnick's communication versus his and how that makes a difference. I think that was actually the Redditor.
Also, Woodnick has been practicing family law for like 20 plus years.
Right.
It's his forte. Like, it's his fucking forte. That's what he does. So I would think he knows how to do things appropriately.
Yeah. Oh my goodness. Okay. David summarizes the issues as 911 call, sweeping hands, email litigations, and daddy. Once again, really showing your immaturity and misogyny here. I think the Redditor forgot to put that in quotations. David claims his response to the bar is too long and way too detailed. So that's why he doesn't read it. Okay.
Yeah, I thought that it's in. I wonder what that. So there's a reason he's not showing it, and it probably makes him look like an asshole. Which, in my opinion,
what did you write in there?
He is exactly. Well, we'll get it when it's closed. We will request it, and we'll get it.
He states that before Mata filed her complaint, he had submitted a complaint against her with the Judicial Conduct Commission, and states that there's a rule that if you file a complaint against a judge, they are not allowed to retaliate against you. He says he reported to the commission that Mata has retaliated against him twice, once by denying Laura's motion for a new trial when she had no authority, and by this bar complaint. Didn't she, rescind that, though?
Yes, but he's saying that, basically she was trying to get away with it, and then she got called out and was like, oh, I'll take it back.
Okay, whatever. He states that a frivolous bar complaint is retaliation, but that's not frivolous. How do you call that frivolous, though? There's a lot of stuff in here that's really legit. You should not have done that. So, at the very least, admit you should not have done that.
He's just saying, well, I didn't coach her, and I didn't do all that stuff that she's saying, and so he feels it's frivolous.
I mean, it's just, at the very least, admit you shouldn't have said the weird daddy comment. Just if you want anyone to believe you're trying to be a better person or a decent guy and you're just a dick in writing or whatever, at least admit that you shouldn't have said that. But he doubles down on that shit. So
I guess he didn't realize he's also a dick on YouTube.
Yeah. Well, I thought he was all right until, well, you guys know the rest. David has asked the bar to dismiss Mata's complaint and that they should report to the Judicial Conduct Commission that they find the complaint to be frivolous. He states that Judge Mata is a judge, but also a lawyer, and as a lawyer, she has done things that would violate the rules of professional conduct that apply to any lawyer, but in your case, she's a judge. He asked the state bar to look into her actions. David states that just because she's a judge doesn't mean she's perfect or above the law. Okay. And then the Redditor says, "Will you admit you're not perfect or above the law? Then your actions have spoken otherwise, David." He thinks
who said that she was perfect or not above the law? Those weren't things in her bar complaint about him that he's responding to. So he's creating this sort of straw man argument and tearing it down when nobody made that argument in the first place.
Oh my, okay. Sorry, I was reading the comments. Thinks the bar won't do anything, but thinks the Judicial Conduct Commission will take action. Okay. David talks about witness tampering and states that he walked through this with the bar in detail. He states that he had a right to know what Mike would testify about and claims that Woodnick only told David that he was going to testify about previous interactions with Laura, the 2 alleged pregnancies, and subsequent litigation. Okay. And? Claims that Mike would never be allowed to testify in a normal civil case. This isn't a civil case, right?
Also, that's fucking false. That's not true.
Right. Without appropriate disclosure, and then the Redditor says this isn't a civil case, it's family court. Oh my gosh. David reached out to Randy Sue Pollock to talk to Mike, claimed she responded bizarrely and said he wouldn't come to trial, but then says that everything changed when Woodnick gave disclosures just days before close of discovery.
That's not true.
Well, wasn't it after he put up the Twitter stuff?
Well, it was before. Mike was going to be there from April on. That was a plan that was discussed. Just because someone who represented you previously in another case says you're not going doesn't mean you're not going. That person was reached out to without being told that was his representation. No one told Gingras that was Mike's representation, legal representation. Nobody told him that. I think he reached out to that person because that's who repped him in his RO case with Laura. And also, you can change your fucking mind.
Right, yeah.
Your lawyer, if that were his lawyer, she could say one thing and you could say, hey, actually, that's not what I'm going to do. I'm going to do this. That's allowed.
Yeah.
Right.
Yeah, you can receive new evidence over time or new information that changes a position.
Yeah.
Okay. David reads his follow-up email to Pollock and then states lawyers are not allowed to lie to other lawyers. Claims he's not what? Claims he's not calling.
Then why are you still a lawyer?
But stated, okay, claims he's not calling her a liar, but stated that she told him Mike wasn't testifying, and then days later discovers that Woodnick is in communication with him. Okay.
He knew so with the response to the motion in limine, he knew that obviously they were in touch.
Yeah.
Woodnick wouldn't be able to mention Mike in that filing if he had not been in communication with him.
States that he left friendly messages stating he just wanted to talk to Mike, but that Pollock did not want to cooperate. Well, wasn't she no longer like the person in charge of him or whatever, or not in charge of him, but
right? And Mike was going to talk. I know we've talked about this before. Mike was going to talk with him until he released that podcast and that picture of them together. He said that day he was going to talk to him, and that's when Mike sent his email response to Gingras saying he wasn't going to.
Yeah, I remember. I did not listen to that podcast. I listened to like a second of it, and I was just like, "This is wrong. I'm not doing it." So I have no idea what that was about, but
yeah.
I didn't see the
picture. Going off. I'm so glad I didn't watch this because it would have given me anxiety.
I know. I feel very passionate tonight. I'm talking a lot. I'm sorry.
You're supposed to.
I'm talking about David. David's anxiety is like coming through the word.
And I'm like, shut the fuck up.
And please, somebody's got to carry us. I'm tired from Sunday night or whatever.
I don't even know what day that was, dude. I was in Australia. It was a different day. So
you were in the future.
I left. Okay, so I left on the 20th, at 11 a.m. and then I got here on the 20th at 6 a.m. So I'm a little all over the place right now. David states that he had the right to interview Mike. Refusing to cooperate was not an option if he wanted to testify at trial. Claims that Pollock said that Mike would show up without being subpoenaed. Claims that there were plenty of ways that Mike could have testified without violating the LOP, but this is where he made the threat to arrest him if he attended outside of a valid subpoena. And then the Redditor says, which would Nick did provide, and you called 911 anyways. Claims that just reiterating a court order is not witness tampering. Okay. Whatever. David also states
that he can interview him. No, notice the deposition.
Mm-hmm.
Schedule the deposition. If he doesn't show for the deposition, and it's the judge didn't move the trial date. If you don't have time to do that and you can't interview him, there's no.
Oh my God!
mechanism.
Wait, do we know somebody who didn't show up for their deposition?
Whoa, no, I forgot about that.
But Patrick, you're saying this is sort of a commonplace procedural occurrence for there not to be enough time to do all this stuff. Is that true?
Yeah, and I mean that's why you get paid the big retainer, because if Mike was such a critical witness that he had to interview him and he didn't have time to depose him, you fly your ass out to San Francisco, or you fly your investigator out to San Francisco, like you find him at a coffee shop, like this temper tantrum for not doing your job is ridiculous. Like, you had a legal mechanism, you couldn't use it, and you didn't go the extra mile. So shut the fuck up.
Right.
Yeah,
and
he wants everybody else to make it easy for him.
Yeah, and put the blame on everyone else for not doing that.
Like, Mike's supposed to fly to him? I mean, no. If Mike didn't want to talk to him by phone, he could have Pony Expressed it. Like, whatever.
Mm-hmm. Absolutely.
Hop a ride on Taylor Swift's jet.
Yeah.
Like, I want to make a difference in the world and I need to find my place. That's why I admire Lauren so much. Thank you very much. Sorry, I probably missed part of your conversation there. I just saw my name and I was like, what did I do? Am I talking too much for someone again? Okay. Let's see.
Well, you're just trying to get through this, girl. Like, I feel you.
Yeah. I don't know. I talked a lot in my video the other day to the point that people were complaining about it, which is hilarious because I got, copyright strikes for something that I clearly transformed way too much. So
people can just fuck off.
They can or they cannot. As long as they don't bother me, I don't care.
I'm just like, if they watch your video and it's too much talking, then stop watching the video.
I mean, I don't mind if people hate watch me, just like don't tell me about it,
Well, exactly. But I'm saying, like, even for their own mental sanity, you can turn the video off. You don't have to watch it.
Yeah. Oh my gosh. Okay. Let's see. We got through that. David also states the lawyer cannot tell the client not to talk to someone else and states that this is witness tampering. I believe Pollock was conveying Marraccini's own sentiments, and also you certainly didn't help ensure that your client complied with discovery appropriately. Otherwise, a change from Mission Viejo to LA would have never happened. That was the Redditor speaking. David claims that his emails...
Can a lawyer recommend that a client not talk to someone else?
I think she was probably just saying he didn't want to talk to you.
Yeah.
Oh, I get it, but I'm just trying to litigate the point here.
Yeah, sure.
Can a lawyer recommend that a client not talk to someone else?
In a civil context, what? I mean, under a privilege, we could recommend a lot of things, right? I think it plays out practically versus legally.
Right.
I would say if I was being an 100% ethical attorney, I would say no. But would I say it's witness tampering? No. What I think maybe is a ethical violation? Yeah.
Because I'm really concerned about the word tell, which is more of a command, versus recommend, which is more optional. So there's sort of this, optional versus mandatory context. I'm trying to figure out if that matters or not.
I think what matters more is that the lawyer never told him not to testify. That is witness tampering.
Okay.
All right. Oh, hold on.
But what you say, it does make a substantive difference, though, Bruce, in terms of the ethical part of it.
Yeah.
Mispronounced name. Thank you for being a member for 5 months. My favorite part about the signaling is Ding is saying I wasn't signaling to her. I was just signaling that she should speak up so I could hear her.
And do you guys know? I don't even know what it's from, but they'll say like, "What had happened was."
See what happened.
So what that part of the video is like. Oh well, I wasn't doing that, but the reason I did that was because it's.
Man.
Yeah. Okay.
He wasn't doing the bad signaling. He was doing the good signaling.
Is there a
want to
camera?
purge yourself.
Sorry. Is Stinchel, do you have a camera angle of the trial with that we can see it?
No, so I contacted the court after I got the initial video and asked if I could have the other angles that were available, say if you sat in the overflow room. And I was told that it only records what it records. So they don't record all the angles and then like edit it together. It's just basically I think it picks up the voice and then the camera goes to wherever the like mic picks up. So yeah, unfortunately I can't get any other. That's all they have is what I posted.
Well, Mada's word against Gingras' word, I go with Mada. I think everyone goes with Judge.
Yeah.
Patrick, did you see this question from Karen Karsten? Thank you for the 5. Patrick, how can DG ask for a new judge when the trial was over?
Yeah. I thought the same thing when I saw that. I was like, what the cluster is this going to be? He can ask for it as a post-trial motion. But when I was reading through the law in terms of change of judge, typically they said once the case is done, you can't do it. But there was some reason why he could in this case. So it would be to answer the question, to be through a post-trial motion. In terms of like the actual remedy, they would have to go scorched earth to redo the trial because it's structural error. Yeah.
Sorry guys, I had to change my ad thing for a second because I had it set to conservative, but when I set my ads to conservative, it ends up being way too many ads, and so I'm like, I have to switch it real quick. Let's see.
Oh, really?
Yeah, I don't know what's up with it. I think it's just because my last couple streams have been shorter, and so there have been more ad breaks during that short window. But
I always thought that would be better for viewers.
I thought so too. That's why I was always doing it like that.
But
if I have premium and watch, I don't have ads. So how do you get revenue from premium members?
You get
premium money that people give YouTube. So
yeah, I don't know how it's
like instead of advertisers paying YouTube and then it going to the creators, it's subscribers or premium viewers paying YouTube, and then the money goes to the creators.
Drunkest Turtle, Australia isn't the same without you, Lauren. Thank you, Drunkest Turtle. I appreciate you. Let's
Speaking of that, I'm gonna beer myself. I'll be right back.
Yeah, you're gonna beer yourself. Okay.
Like,
what?
He's just gonna dump it all over himself for us.
No talking out of my butt. No moose knuckles. No vomit stories.
No moose knuckles.
Okay.
Hey, I'm the only moose around here, buddy.
Show us your knuckles.
Oh, jeez.
Oh my. Wow. Okay.
You got to buy me dinner first.
Oh, all right. When? Tell me when and where. So I have a take on the how he could file for a motion for new judge.
Sure.
Because he claimed bias in the motion before the ruling, and the rules allow for a judge change, but not really about. It's supposed to be before trial or before the hearing, but that was what the Fisk presiding ruled on. That makes sense.
Yeah. Huh. Okay. We're almost done with this part, guys. Hang on. Let's see. We did that part. David claims his emails demonstrate that he did not attempt to prevent Mike from attending, claiming he was extremely professional.
Is that when he was swearing at everybody in the hallway or whatever?
And then David, it says, the Redditor says, it looks like David omits all the personal emails he sent to Mike from his response to the bar, including the one where he suggested Mike talk to Laura. Wonder what the bar would think about that. Oh, wait, they have that from Mike himself in his bar complaint against David. Yikes.
Yes, they do.
David claims nothing here is complicated, that he did everything right, and that the facts speak for themselves. He claims he acted in good faith throughout this case and that he did many things behind the scenes to try to be fair and just to everyone. Well, let me finish this first. States he will never be disbarred for anything related to MATA and that he loves rules, but others don't care about the rules like he does. Well, when you interpret them the wrong way and try to apply them to people that you don't like or people who are saying things you don't like, then you're not really loving the rules. You're loving the way that you can wield them as a weapon.
He also conflates these statement of fact with opinions. So if he says, I'll never be disbarred, that's a statement of fact or knowledge, not I think I will never be disbarred, but I could be, which is an opinion where you're expressing maybe a confidence level. And he constantly conflates these two in his speech, whether it's in a blog or a YouTube video or his filings. And I just find it very, I don't know, it's not very disciplined. It's not very precise. And I would like more precision.
Oh, did you see him showing his 1999 free, what is it called? Free use, what's the word?
What?
That you were saying that's what he's fighting you on, Lauren.
1990.
No, the free use of his video. What's it called? I can't think.
Oh, the fair use thing?
Fair use. Yes, thank you.
Oh, the textbook?
Yeah, the textbook.
Which video was it? Because he's been
today.
Showing up
the one today.
Okay, well, tonight. I was born in 92, so I feel like things have changed since then, David.
He was like, not so much has changed about fair use, but then he was like, but I wouldn't go to this textbook to get like current information. I'm like, okay, well,
I did hear that
contradiction.
That reminds me, I actually have a book that looks worse than David's.
Dude, that book is literally older than me. That book just had a birthday like me, but okay.
I mean, did he read something from this book or what?
No, he was just saying like, I know a lot about fair use. Look, I had 3 textbooks I had to read before I became a lawyer.
Well, that's fine. I mean, like at the beginning of the stream, I said I'm not saying David doesn't know anything about copyright law. I'm saying he doesn't know anything about me, and he doesn't know anything about the video he struck because he didn't watch it.
Yep.
That's not very specific either. Like just holding up a book and claiming you're an expert, that's sort of an appeal to authority, which is another fallacy.
Here's the Bible. I'm a God-fearing lady.
Yeah, I mean, you could be the most prominent scientist in some field and still get something wrong one day. Like that you have to actually prove your claims with direct evidence, not with these sort of appeal to authority or appeal to tradition or some other fallacy.
Yeah.
Dude, I don't know, man. I can't hear that and not think of me just like at Bible study, like, I got a Bible. I know everything about Jesus.
Oh boy.
About who? Who do you?
I wasn't.
Jesus.
I didn't bring up religion, Lauren. Oh my gosh.
Look, man, I went to church when I was growing up. I got bored.
Did you ever sing the Hub song?
Which one is that? Go ahead.
He's my hub, hub, hub. The hub in the middle of the wheel. He's the lily of the valley, the bright morning star. Makes no difference what you say. I'll get on my knees and pray. I'm going to sing until the day that Jesus comes. Yeehaw!
I don't think they teach that to the kids.
Did you have to do the yeehaw at the end?
Yes, you
did.
Was
this in Oklahoma or what was?
No, no, and we sang it on the. I'm not religious anymore, but we sang it on the softball bus. That was like that and 99 bottles of beer. Those are our 2 songs.
Wink says,
I will defend you here, Stencil. I didn't think you could sing, but it was good.
No, I have hidden talents.
I give props to your singing. Yeah, that's for sure.
Oh, thanks.
Maybe choose a different song next time. Sabrina Carpenter or something. I don't know.
He burps at the end of his video and then says he'll do better, just like the DM from Anya suggested. Okay, if you're going to do better, you might want to release that copyright claim before I have to start a legal process, but you only got a little bit of time, buddy. So go ahead. Do better.
Well, I'm glad he's listening to Anya.
Whoever Anya. Praise
Anya.
Anya.
Screaming at him Sunday night. That didn't work.
Can I give a closing legal thought on the complaints?
Oh, yeah, go ahead.
So I actually think Mata's complaints are really conduct based, but I think the complaint that he has to be the most worried about is Marraccini's complaint about candor to the tribunal. Like his decorum is one thing, and that's subject to interpretation. But whether you were candid with the court or not, that's like a very fact based thing that can be figured out. And if the bar can prove that you lied, that's a really big deal, and that could create a lot of trouble for him.
Yeah, Runkle seemed fairly impressed with some of the items in the Mike bar complaint, I think, as well. I don't know if you've seen that. He did a live stream covering it.
I think I saw up to actually probably right there when he was talking about don't do the crimes.
Yeah. I don't give legal advice, but guys, don't commit crime. The Runkle stream was what? Was it last night? Oh my gosh.
Yes, it was.
I can't know because
I can't even. Yeah, time has lost all meaning to us.
Even for us with this, like, I feel like yesterday was insane.
Yeah.
I do want to say, I want to give a shout out. They do not follow the case at all. But I got the doc from a very, very, very kind friend who lives like about 3 hours from Tucson. Cool. And I put out a favor request, and they came through, and they're never going to hear this video unless they send it to them. But thank you.
So I'll just send this to everyone 3 hours from Tucson, so they get your thank you note. Okay, so since I've been getting so many complaints about my talking, I'm gonna put the link to Essential Ninja reading this in the chat here. So if you don't want to hear me talk, please go there. Please
go hear this voice.
Yeah.
I did. I laughed.
They're crazy.
I had to cut out many takes because I was, reading it live and had some feelings about it.
Dude, I used to do bloopers. I should bring that back.
Oh, you should. Oh, absolutely. I love bloopers.
I listened to you, Snitzel, on 0.75 playback.
Oh man.
And I was surprised you didn't sound drunk.
Wait, you slowed it down to 0.75?
Yes,
0.75 will make people sound drunk, because I did that accidentally on a Dave stream, and I'm like, Dave, what is wrong with you today?
I'm gonna have to try that.
I listened to my Audible books on like 0.885. Like, it's so much better.
I tried to read this faster than I normally do because I knew it was going to be so long. So that's funny that you say that.
Yeah, I did it mostly because of the cases and stuff.
The story involves sex, celebrity, even an
this story involves
sex.
Salacious facts.
Okay. Are you drunk?
You don't even have to buy Schnitzel Ninja dinner first. Wow.
The cast includes an inexperienced trial judge who apparently broke the law to ensure.
Oh, there's the drunk voice right there.
Okay, now do Omar and tell me which one's worse.
Wait. Okay, hang on.
Oh my god.
Oh wait, I should have clicked on that one.
Yeah,
it's so funny. It's funny you're doing this because I did this to.
He sounds like he's unplugged.
Wrecked. Dude is wrecked.
Some use case text. I don't know what David uses, but I use Lexis. It's pretty freaking comprehensive. Anywhere in the country, a governing body of law.
Oh my god!
Sorry, Omar. Please don't sue me for copyright. I don't have another $150,000.
This is so wrong.
You changed the playback speed. You're good.
Wait, can you guys hear this? I did this to Gingras from his video.
I'm trying to pretend like I can see you because I'm tired of the reflections in the glasses.
Whoa!
I'm tired of the reflections.
Oh.
I'm more worried about the context of the content of what he's saying.
He took his glasses off and he was like, "Oh, I'm so tired of the reflection of my glasses."
Somebody said to do mine. Let's find one. Which one I want to do?
We should play the ejaculate part of Gringis.
Oh, Dave Neal is
Please
just
do it.
ejaculating all over himself after the court ruling.
Let's see. Hang on. Let's see this one. Now, wow, I'll go ahead and block you so you won't keep embarrassing yourself. To be clear again, 1, I am not shy, I'm not playing hard to get, and I am not interested in the slightest. 2, any further attempts to obtain my address will be considered harassment and reported as such. 3, if you see me in public and touch me, please remember Florida is a stand your ground state, and I will
Go home, Lauren. You're drunk.
myself accordingly.
Accordingly. And then
I
you
love
laugh.
this kind of shit. This is so funny.
Oh man! All right. I probably won't go through this whole thing, guys, because it's a whole freaking 73-page lengthy appeal, like we said before. Okay. Well, let's get through the introduction part, and then we'll see how I feel after that. This case presents some bizarre, interesting, frightening, and salacious facts. The story involves sex, celebrity, even an alleged fake pregnancy. Am I reading Cosmo Girl?
Okay, wait, can I say something also? This file is called this isn't what I named it. This is called Gingras Appeal Use. I'm like, what was the not use one?
Is there anything
Wait, it just says
redacted, or-
use?
It says Gingras, I'm assuming it says appeal and then use. I was like, well, what was the original that you can't use?
Boomer. I
Did
usually
your friend
put like
make the
V
PDF
final.
or
I don't know who made this PDF. Specifically, I don't know who specifically made this.
it's possible while they're trying to make a PDF, they had to do it a few times and
Yeah.
get it right, get the page, you know.
It's just
Sorry,
I
I'm
saw
still
that.
reading. I'm still reading in 0.25, and I just
This case presents some
Oh,
bizarre.
no.
the story involves sex.
Well,
Oh,
I mean,
no, this is
maybe,
terrible.
well, oral sex.
I just read a line ahead, and I'm repulsed already.
I'm gonna listen to that. I don't care.
They're eating the dogs.
Oh no.
The cast includes an inexperienced trial judge. Oh God, David! Why, David? You couldn't even get through a paragraph.
Right.
An inexperienced trial judge who apparently broke the law to...
Breaking the law.
Okay. Broke the law to ensure a pyrrhic victory for a famous litigant from a popular TV show. At the end of the day, the strange facts of this case are almost irrelevant to this court's task, answering a very simple yes or no question. Do the rules of procedure matter, or can the rules be casually tossed aside when they require an undesirable result? I mean, so when you're right, a statement or a question like that can be very powerful, but when you're wrong, it's just annoying. So it depends on how they read this. So like whoever's reading this, it depends on how they feel about it, because they could go back and read that question and be like, oh my God, you're the most obnoxious person in the world. This is so stupid. Or they could be like, yes, totally. Yeah, man. You know? So this rhetorical question answers itself. Of course, the rules adopted by the Arizona Supreme Court matter. Like all other statutes and regulations, procedural rules carry the full force of law. All judges, all lawyers, and all litigants must follow them, whether they agree with the rules or not. Sir. It is undisputed that did not happen here, sir. The trial court...
Does anybody know why he says it's undisputed?
I don't know.
That one really confused me, because my assumption is that because there's going to be a response filed by the respondent, that they would probably dispute this.
Yeah,
but
you don't want
I'm
to
not
lose
sure.
credibility in your own brief.
Well, I mean,
you should have told him that before he wrote this.
Buckle up.
Buttercup.
I know.
The trial court ignored one of the clearest and arguably the single most important rule in all of civil litigation, but this is family law. Is that right? Like,
he will be trying to act as if they're both the same thing for the entire.
Okay. The safe harbor provision of Family Law Rule 26 the family court variant of Civil Procedure Rule 11. Okay, I gotcha. Rather than, I should have read ahead, my bad. Rather than applying the safe harbor as the law requires, the trial court. I'm not back in the South yet, yo. All right. The trial court transformed it into the proverbial serene door on a submarine, a pointless, useless nullity.
Also, wait, this next one, can you do as Gingerbread Man, please?
This whole paragraph?
Yeah.
Oh, why?
Hold on.
Oh.
Wait, that's not vodka.
Chat, someone help me. I need help.
Yes, it is.
What's in it? Cranberry?
Someone rescue me.
Got it.
The obvious of this legal error is surpassed only by the ease. Bread. Court may correct it by reversing the lower court's judgment and remanding this case with instructions to dismiss the action with prejudice. Of course, this appeal raises other arguments and issues, but the court need not reach or decide any of them. The court's error of law on the first point is fully dispositive of this entire appeal, Daddy.
Why is your gingerbread a Southern grandma?
What was the purpose of that?
Entertainment, baby.
Well, no, I just thought there was going to be something more sexual in there, but okay.
Oh no, I just wanted to hear the voice.
That's fine. Then you can read the next paragraph. Okay.
Because we need to save the gingerbread boys
I already
for sexy
did read
time.
Right, that should have been the first paragraph.
Listen, I read that in a Southern cookie voice, so like you need to read this next paragraph. That's all I'm saying.
2, statement of the case. Should I do my Omar impression like Gingras?
Sorry, are we on 0.15?
What?
Did Gingras do an Omar impression?
Multiple times now, yes. And I will say,
oh, God.
Omar has a very lovely voice that can do some things for some people. Okay.
Not me.
And hearing Gingras do that, my brain is like, no, fucking stop now, please.
I actually never heard him do the impression. I heard he did an impression. I did not actually hear the impression.
I have a screen recording for you.
Oh, I don't want it.
Look at me, Daddy.
And he got a new microphone. He got a $700 camera. Looked it up. I looked it up after he showed what it was. $700, unless he got it on a Black Friday deal, which
he's got the camera I have that I'm using right now.
Okay.
Look at me, Daddy.
And then a new mic. He said, oh shit, I can't think right now. Anyway. Okay.
Wait. I just got it back. Okay. Are you ready?
What?
Most points in this appeal involve legal errors which are subject to de novo review. Although Laura disputes many of the trial court's factual findings, she recognizes this court will generally defer to the trial court's factual findings, but review de novo all legal conclusions. Some dude versus some other dude in 253 blah 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 shit. That's the best I can do.
Oh dear.
It still had a little twang to it, dude.
I love it.
There's just not the shock factor for me is not there anymore.
It's got to be organic.
Yeah, all right. Thus, plentiful and egregious factual mistakes notwithstanding, factual errors are not the primary focus here. With those standards in mind, Laura offers the following background facts for context. Laura's pregnancy claim made 2023. In her establishment petition, ROA 1, and later in her trial testimony, ROA 129. No. Okay. Petitioner / is it appellant or appellant? Is it appellant?
I said appellant. I don't know. I didn't look it up.
Petitioner / appellant Laura Owens. Laura claimed that on May 20th, she had a brief one-night sexual encounter with respondent / appellee Clayton Echard. Clayton. Didn't he say in one of his videos that they were in a relationship?
Yep.
Okay.
Yeah.
11 days later, Laura learned she was pregnant by taking a home pregnancy test, or HPT. Laura sought medical confirmation of the pregnancy the next day at a Banner Urgent Care facility in Scottsdale. The pregnancy test at Banner Urgent Care was positive.
Also, how much do you want to bet he went to the hay bales timeline and just like lifted all of this information? he's like, what case am I litigating?
On June 17th.
No, he doesn't have time for that, Snitchell. Remember, he's too busy. Doesn't have time for that.
On June 17, 2023, Clayton invited Laura to his home in Scottsdale to discuss the situation. Is that what he invited her to do? What happened before that, David? Okay. When Laura arrived, Clayton, doubtful of Laura's pregnancy claim, surprised her with a home pregnancy test, which he insisted she take immediately in front of him. Laura
Isn't that contested a bit in the deposition?
Yes.
Mm-hmm.
Laura took the test Clayton provided. It was positive. Trial court finding regarding June 17th meeting. Clayton provided a pregnancy test for Laura to take. Both parties agree the test was positive, but they don't agree it was taken in front of him or not. Okay. Clayton later confirmed seeing the positive test in an email entitled Something to Consider, which he sent to Laura a few days later on June 21st. In that email, Clayton made several admissions about the pregnancy. Okay, well, first of all, again, I'll say this again. When you're being gaslit about something and you have this evidence right in front of your face and you're like, why would any human being be so awful as to fake something like this? Of course you're going to rack your brain for all the possible options.
Exactly.
Also, it's not a pregnancy. It's an alleged pregnancy.
Right.
And it's not an admission. It's a contested statement of fact.
Even after seeing a positive pregnancy test, I still had doubts in my head. I feel like that is directly contradictory to what he's going to do. Something was telling me to look deeper into things, so I did, and I came up with a theory that could wow, Lauren, talk. Okay. A theory that could potentially be realistic. Considering you only performed oral sex on me, which is something she redacted when she posted all this to Reddit, and no vaginal penetration occurred, the chances of you being pregnant seem considerably low. Although, again, maybe rubbing up against one another allowed a sperm to make its way inside you, but it's a very low probability. Nonetheless, it is one. Okay.
Maybe it took an Uber. I think my work here is done.
Got it. That's the one.
Laura and Clayton discussed the situation over the next several weeks, but could not agree what to do. After another positive HPT on August 1st, Laura filed her establishment petition later that same day. Okay. And what is the latest timeline of when she allegedly had the miscarriage? Does anybody remember the date?
Which one? Which timeline?
The most
deposition
recent
timeline or testimony timeline?
Most recent was November, but whatever November would be before the 20-week mark.
Okay.
Basically that last one, November 2nd, was it, that she thought she was still pregnant, but she found out she actually probably wasn't pregnant at that time. And that's why she testified that she was pregnant.
Okay. Mika said
to really focus on those, those photos of the discharge, which I believe was back.
He doesn't mention those at all in this.
Late July, early August, then November.
No, those are mentioned somewhere.
Cat Lady Ballerina, thank you for the $2. This is so bizarre on an edible. I'm so confused. Are you talking about the gingerbread voice?
Slow down.
Voice? Hey, Julia, what's up? Okay.
Maybe he does. I did read this, but I guess I don't remember.
Oh, so you want to read it again? Is that?
Nope.
Litigation begins. After 2 months of unsuccessful private discussions and multiple positive pregnancy tests on August 1st, Laura filed a petition to establish paternity. On August 21st, Clayton filed a response denying paternity.
And parenting time.
Oh, yeah, that's right. Forgot about that. From the inception of the case and for months to follow, both parties were pro se. In September 2023, Laura and Clayton agreed to submit samples for DNA testing through a company called Ravgen. A Ravgen representative later indicated the tests were inconclusive because there was little to no fetal DNA found. Thus, there was insufficient genetic material to establish or exclude Clayton. I'm sorry, that's just a joke. Clayton is the father within the 95%. Within the 95%, you fell a little short.
They needed to go on Maury.
Yeah.
And say you are or you are not the father.
Right, dude.
That's what they needed. That's what's missing here.
Bad news arrived a few weeks later. On October 16th, Laura had a blood test which showed her HCG pregnancy hormone levels were 102. Although this test confirmed Laura was still technically pregnant, the level of 102 was far lower than normal for a healthy pregnancy at that stage. Oh, I mean, she never had a level higher than that was really confirmed to my knowledge, right?
Right.
Okay. That's probably a normal level for somebody who's like supplementing, trying to get their HCG levels up. But okay.
Yeah, because if you have like if you're like postmenopausal, your level is like 5.
Mm-hmm.
So that's a level with very, very, very obviously little hormone, HCG.
Thank you. I suppose I have that to look forward to.
Both of us, baby.
Yeah, I think we were looking at 102 is around, if you in a normal pregnancy, it'd be like 4 weeks or something. Is that right?
Mm-hmm. Yeah, very early on.
At the beginning.
Yep. Which is why, I mean, they say the date, if your cycle is regular, they'll say it's 2 weeks prior to your ovulation, right?
Mm-hmm.
And you don't really notice you're pregnant right away. It's usually 6 to 8 or even later weeks until you start having symptoms. I thought I had leukemia when I got pregnant.
Oh my. Oh.
Because I had an IUD. And I was, in my mind, I was like, no, I'm not pregnant. One of my friends said, well, maybe you're pregnant. I was like, no, I'm not pregnant. There's no way. I obviously have leukemia. That's what's going on. And then she was like, why don't you just take a pregnancy test and make sure? And so I took it, and I'm glad it was not leukemia. Anyway, I was convinced.
Oh my god. Teresa says it's good Lauren's inside reading. Keep her off the street. I mean, I'm not going to totally disagree with that.
I think San Francisco can handle it.
Oh my god, prime rib. You gotta take a picture in front of prime rib before you get out of there.
If I can't, it depends on tomorrow. My flight will probably be delayed, and if it is, then I'll go. But if it's not, then I'll just have to get out of here. We'll see. I kind of want to go home.
So it'd be like, hey, just delay my flight, man.
There's also a Godiva, I think, chocolate factory down right over there.
Oh, okay, cool. All right, let's see. On November 14th, Laura saw a medical provider at MomDoc, an OBGYN facility. At that time, Laura was given 2 pregnancy tests, both of which were negative, confirming her pregnancy had failed and she was no longer pregnant as of that date. My immediate question there, obviously, which we all asked, is did Laura ever see MomDoc before, or did she self-report her pregnancy? So, after learning of the miscarriage in mid-November, Laura, who like Clayton remained per se, filed nothing further in the case. She pursued no discovery and otherwise had no case-related contact with Clayton. Due to inactivity on December 4th, court administration notified the parties the action was scheduled for dismissal. After receiving the notice of impending dismissal, Laura filed nothing further and took no action to keep the case active. However, before the case was dismissed, Clayton retained counsel Greg R. Woodnick, Esquire, who appeared and immediately filed pleadings seeking to avoid dismissal. And the fact that he acts so outraged by that is like what gets me every time. I'm just kind of like, dude, no, absolutely not. You cannot like actually think that you're in the right when you're saying like this guy who clearly has been wronged in some way should not seek justice for himself. Like, what kind of lawyer are you?
Yeah, and Greg knew about Mike during his case, but Mike, there was just so much they didn't know. Like, even though they knew each other, they just didn't know. And Mike wasn't really able to help him very much. But then, I mean, I know we're all on the same side of this, but just to put it into context, like, Woodnick had been through Greg's case, knew about Mike, didn't know about Matt until Laura mentioned him in her deposition.
Wow, so Woodnick has known about Mike for a while then.
Yes, exactly. But it wasn't, his case is different than these cases, and it wasn't, you know, he was able to help so much in this case because of the laptop and you know, establishing
to
this
me,
pattern.
the laptop being analyzed was really where we connected the dots to seeing how similar the cases were.
Yes.
Yeah, I remember that, and seeing the connections started clicking to me, going over it with on this channel or Heinz's channel. Yeah.
Mm-hmm.
I guess maybe the abortion coercion part would be somewhat similar, but only if Greg had said, I didn't believe she was ever pregnant, but I don't think that he had chosen that route in terms of how he wanted to litigate it.
Not legally, but in conversations with her.
Oh, yeah.
Yeah. Oh, yeah. We all heard the video where he's like mocking her.
Oh my God, I'm so excited to have our kids.
I have the gene. Do whenever I do
Yeah,
that.
yeah. I know how to read an ultrasound. Oh my God.
I know how to read an ultrasound from the woman who said she was having boy-girl twins and is now like, well, I don't really know.
And she's like, that's not how it works.
Tilted Lawyer says after his, I guess, video earlier tonight, Gingras' response is, "You're wrong for reasons to be determined." Winks says, "Saw that and enemy, but not enemy." So apparently Omar is working with the enemy, and I don't know if the enemy is me or someone else, but he seems to have lumped me in with, I guess David thinks that me and like 16 other people are behind different Twitter accounts, and so he is accusing me.
Except it's not actually you, it's Greg Gillespie.
Well, yeah, of course it is, but
don't anyone tell.
I'm just like, what do you mean enemy, dude? Like, fuck. Okay. Anyways, first on December 12th, Mr. Woodnick filed a motion for leave to amend Clayton's response. Next, on December 13th, Mr. Woodnick filed an expedited motion to extend the dismissal date and a request for an evidentiary hearing.
Oh, wait, can I interrupt real quick?
Yeah, go ahead.
So Omar, I'm looking at the first page of Laura's complaint, and it says paternity, and then there's check boxes for the other things that she wants, which I think would open the door to the chapters that you were talking about. She checks legal decision making, legal custody, parenting time, and child support. So sanctions through those doors would be open each of one of those chapters.
Yep.
Yeah, the parenting time and child support.
It's page 1.
These are the big manipulation tactics, right? Like, this is what you're threatening this guy with.
Yep. Yeah. Omar, I listened to him on 0.75 today, and I think that
Did he sound drunk?
It's nailed. Nice. No, not as drunk as what we've had before, but I think he's got this case nailed. I only had like one thing I wanted to even add to what he said. It was like the fact that in her Medium article, she says she specifically filed the case to stop Clayton from leaving the state. I don't know if that's borne out in a deposition, but if it is, that's even more of a sign that her intent was more than just paternity. It was custody.
Yeah. Yeah.
That's a big one. Yeah, because that was in a Medium post. I remember that one.
Omar, Patrick likes to watch people talk in slow motion. In case you didn't know, you sound drunk.
I had to get all those case citations written down. But yeah, I think Omar has it cited incorrectly.
All right. Let's see. Just days later on December 22nd. Did we go through that one already? Okay. Laura moved to dismiss her petition with prejudice, explaining petitioner is not now pregnant with respondent's children. Here there is no paternity or maternity to establish, as petitioner is no longer pregnant. Accordingly, this case must be dismissed. Okay. On January 3rd, after Laura moved to dismiss her petition, Mr. Woodnick filed a motion for sanctions. In his motion, Mr. Woodnick claimed Laura violated family law, Rule 26, by filing the establishment petition without medical evidence. Yeah. And then as the quote says, petitioner filed the underlying action for an improper purpose without medical evidence to support her claim that she was pregnant and or that she was pregnant by respondent. Petitioner could not have become pregnant from the limited encounter the parties had and therefore premised this entire action on fiction. Petitioner violated Rule 26 in her petition and subsequent filings. I don't see a problem with that.
Also, I want to say that the reason Clayton's side withdrew this motion is not the reason Gingras is claiming.
Patrick Omar says, email me, I'll share my sites.
Ooh.
Oh, thank you.
Give us some sites.
What kind of sites?
Slide into those lawyer DMs.
Oh my God. All right. Okay. Immediately following the Rule 26.
Sorry, I was reading that. Thank you. I will do that. Thank you. I'm reading Clayton's answer here on the side.
The record becomes a confusing and contradictory mess. Wow, that's Interesting, you should say that, but okay. To begin, on January 21st, the trial court issued an order granting Laura's motion to dismiss. In that dismissal order, affirmed for a second time the next day, the court indicated the petitioner advises she is no longer pregnant and has filed a motion to dismiss. While the court will grant the motion, the issue of sanctions and attorney's fees remain. So what is the problem?
Oh my gosh, I think I just found the bomb for Gringus's case.
Like a good bomb or a bad bomb?
Bad for him.
Oh,
Lauren, this is when you press the breaking news button.
I don't have it, so.
Well, so in Clayton's page 10 of Clayton's answer,
okay,
he says specifically, I want her to pay. He wants a finding of non-paternity. He wants her to pay all costs. And then he says he wants an award of attorney's fees pursuant to ARS 25-8096 and 12-349, as this case is groundless.
Mm-hmm.
So he's already at the beginning invoked.
That was there from the start.
Yeah.
Yeah.
And
We've seen that before, yeah.
Never asked for Rule 26.
Awkward.
So, yeah, it's really bad for you. Really bad facts, bro. He said he had good facts.
Ooh, okay. Yikes.
Back up your claims with evidence.
I'm dropping a link in the chat.
On February 2nd, the trial court issued a new order setting an evidentiary hearing regarding the issue of sanctions and attorney's fees for February 27th. Shortly before the original hearing date, on February 21st, the court issued a new order denying Laura's motion to dismiss, despite the fact that the dismissal motion had previously been granted twice a month earlier. I don't understand that. Someone help me out with that one. Like, I understand what he's saying, but I don't understand how it applies. Like, if that makes sense at all. No one?
I'm trying to catch up. Where are we here? We're on...
The thing about how they denied Laura's motion to dismiss after apparently granting it twice.
Oh, yeah. I think that this is something that it's really in the court's hands. Like, we don't know what the court needs to decide this issue. Like, when was the case dismissed? Was it dismissed? And if it was, what was dismissed? I think that the court needs to decide based on the facts that it has.
Well, here's the thing. This is a motion. And I think the contradiction he's trying to point out is that this motion was granted and then the motion was denied. But when I read through it, it looks like is it possible to approve or deny a motion in part?
Mm-hmm.
Because I think that's what happened here. They basically said, we're dismissing the paternity issue, but we are not dismissing the fees and sanctions issue.
Mm-hmm.
So to me, because there were two different parts in one larger umbrella motion, it's not that the motion was, inconsistent, A and not A. It was more like, well, we have A and we have B, and we have different answers for A and B. That's my take, but I'm not a lawyer.
Yeah, they can definitely deny it and grant it in part. I just think that if a case is dismissed, that's a pretty big procedural step.
This isn't about the case. This is about a particular motion.
Oh, this is about the Rule 26 motion?
Well, it's the motion to dismiss.
Well, when I say the case, it's because the case goes away if it gets dismissed. But yeah, the motion to dismiss is it has a lot of procedural impacts once it's granted or denied. For example, you can't seek Rule 11 sanctions in civil court after the case is dismissed. So I think that it's better if she didn't dismiss any of it. But I agree with you that I think that that's what happened, that she dismissed part of it.
I see. Okay.
And yes, Winks, it does. If the doors were opened, as I call it, to different chapters, that would make the next 20 pages we're about to read moot.
Oh God, 20 pages, jeez. Okay. Matters then became even more convoluted and confusing. First, on April 3rd, Clayton moved to withdraw his Rule 26 motion. After more than a month passed without any decision from the court on that request, on May 10th, Laura filed a motion for judgment on the pleadings, asking the court to deny Clayton's still pending Rule 26 motion as a matter of law. That motion argued that because Clayton failed to comply with the procedural requirements of Rule 26, sanctions were unavailable under Rule 26 or any other authority, such as the court's inherent authority. To me, that's like kind of bullshit, but okay. The motion also renewed Laura's request to dismiss the action since there were no other issues for the court to resolve. On May 16th, the trial court issued an order granting Clayton's request to withdraw his Rule 26 motion for sanctions. That order did not, however, resolve Laura's request for judgment on the pleadings, nor did the court mention Laura's renewed request to dismiss her petition. About 2 weeks later, on May 28th, the court issued yet another confusing order, explaining that due to a clerical error, the court had intended to issue a ruling on Laura's motion for judgment on the pleadings, but due to this undescribed error, the court's decision was not remitted to the parties. So that is that something that could have possibly been discussed like in emails or something? Like I don't know. But did they really just come out one day and they were like, "Oh, sorry, forgot about this"?
I do remember a clerical error.
Yeah.
Minute entry going out.
There was a minute entry that described it. It didn't describe it in great detail, but it did describe it. So, I mean, he's sort of, he's complaining it wasn't detailed enough, but
okay.
I don't know.
Well, I mean, I also was kind of confused by that.
Again, if you are complaining about it, then file a motion for a written decision on it. If you didn't file a motion for a written decision on it, stop complaining about it.
Yeah. He complains about a lot of things in this appeal brief.
It's a weird quirk in Arizona that you have to not have to all the time. I don't know that for sure, but it appears that some of the time, if you want the judge to explain something, you have to request an explanation.
Okay.
Right. Okay. Let's see. The court discussed various arguments raised by each side on the question of whether Laura could still be sanctioned given that Clayton's Rule 26 motion was withdrawn and no other sanctions motions were pending. Inexplicably, the court concluded Laura's legal arguments regarding sanctions were moot. Therefore, let the record reflect the court declines to take further action.
And we just showed that that was false because there were other requests for sanctions pending in Clayton's answer.
Mm-hmm. Yeah. Okay. Hold on, I didn't see the private chat. Oh, she's back. Okay. There you are.
Hey, yeah, my internet went out. Literally, Natus was like, I think I found the bomb. And then like everything went Siri, and I was like, no, what happened? What's going on? And then like my internet just wasn't working.
Dude, I'm not gonna.
You said breaking news sound. I thought you were there.
No, I wasn't. What happened? What did you find?
Okay, so on Clayton's answer, it's a court form, and the last part of the form it says other orders I am requesting, and Clayton says I, Clayton Echard, am requesting court-ordered paternity test, and that the party pay all costs. I also request an award of attorney's fees pursuant to Arizona Rule. And I can't see if it's a 25 or a 26. Yeah. Arizona Rule 25, 8096, and Arizona Rule 12349, as this case is groundless and lacking in merit. We have never had sexual intercourse.
Mm-hmm.
Wow.
This was his original response to the petition to establish paternity when he was pro se.
And so it completely undercuts what Gingras is saying here about how when the Rule 26 thing was dismissed, there were no more motions for sanctions pending because there's motions right here from Clayton.
And that was never ruled on, right?
Exactly. Until it was granted in the order, the final order.
Yeah.
Wow.
At the very end.
Wow, and he did that himself.
Yeah.
And this is why, like, less is more, Gingras. Like, people like intuitive, practical arguments.
Yes.
People like things that make sense to them. This committee note, like, shit, like, I don't know. You're asking a lot from a lot of people, and whereas this is just clear. Clayton made a motion. It was never ruled on until it was ruled on in the end. What you just said is factually inaccurate, and we can prove it.
Right here.
Look at me, Daddy. That's all I have to say.
I owe $156,000 now.
And I'm gonna make you pay it.
Oh my gosh.
Hey, she and I both apparently, right?
The thing that just really blows me away is if they were really sincere about wanting all this to go away, like the judgment is done. Just pay the bill and go home. Like take the L, as
Right.
Dave Neal likes to say,
Mm-hmm.
and just pay the bill and go home and you're done. But no,
That brings up like the
here we
first
are.
thing I wanted to say about this, which is like, no matter, I totally agree with you, Bruce, because no matter what happens with this, it doesn't change anything about what the judge said factually happened.
Right.
Mm,
So why are you
Right.
here?
Mm-hmm.
And better question, we're here because Gingras is a walking train wreck. But like, none of this appeal stuff is, relates to what Laura has done.
No.
So it's
Right.
like, it's hard to, that's why I'm like, okay, not watching his
Well,
videos, because I'm like, this isn't.
he wants a win on his record. It's not about what's right for his client, in my opinion. He wants a win on his record. I think Dave said this
Yes.
today in his video. And that's the best I can posit.
Hmm.
We're gonna find out. It doesn't look good.
Deanna says she hasn't even paid him. He said it in one of his streams. He thinks he will get paid by Clayton when he wins. Well, if he doesn't, I guess I'm the fallback plan. But I gotta tell you, bro, I'm a lot in the hole. So you don't want to count on that. You might want to find someone else to sue.
I have lots of holes.
Anyways.
I think my brain is rebooting.
Following a 2-hour hearing on June 18th, the trial court issued a lengthy decision which contained findings on the issues of sanctions, paternity, attorney's fees, and costs. Many of these findings are either directly contrary to the admitted evidence or supported by no evidence of any kind. In the end, the court found Laura acted unreasonably when she initiated litigation without basis or merit. Without an authentic ultrasound, sonogram, physical examination, and in conjunction with a belief she passed tissue in July 2023, the court finds the underlying petition premature at best. What does he have a problem with about that? That's absolutely factual. Okay. In the post-trial ruling, the court again recognized Laura's argument that Rule 26 sanctions were inapplicable because Clayton failed to comply with the procedural requirements of Rule 26. The court further noted a separate problem. Clayton's Rule 26 motion was withdrawn. The question thus becomes, can the court still award Rule 26 sanctions considering respondent's withdrawal of his motion?
Yes, case closed.
Without allowing any input from the parties, the court held, despite the withdrawal of Clayton's motion and ignoring his failure to comply with the requirements of Rule 26 and contrary to its prior order, holding the issue of sanctions was moot. And despite the fact that the case had previously been dismissed twice, sanctions could still be awarded sua sponte. So it wasn't like that one part wasn't it dismissed, right? But not the whole issue of fees and sanctions.
Right.
Yeah, I think that's what the trial court will have. That's what the appellate court will have to decide. But I think this appellate court right here agrees.
Okay. All right. In addition to awarding sanctions sua sponte under Rule 26, the court also concluded Laura knowingly presented a false claim, knowingly violated a court order compelling disclosure or discovery such that an award of attorney's fees and costs is appropriate under ARS 25-415 and ARS 25-324. The court later awarded Clayton costs and fees in the amount of, it's about $150,000, right? And a judgment entered on August 16th. So this here, the knowingly presented a false claim. How do you at this point continue to harp on that? Like, how do you continue to argue against that when you yourself are admitting behind the scenes, like, no doctor ever told her she was having boy-girl twins? So, post-trial developments. Before the final, oh God, I know it's just going.
This is, yeah.
Okay. Before the final judgment awarding fees / costs was entered, several critical events occurred. These developments warrant further discussion as they relate directly to legal arguments presented in this appeal. First, immediately after the trial ended on June 10th, Laura learned several individuals posted videos on social media claiming the trial judge's father, Mr. Harry Howe, personally attended the trial and allegedly spoke with them about the case. Among other things, these supporters claimed that Mr. Howe told them he discussed the case with his daughter, Honorable Julie Mata, and that she printed out case-related documents for him and said, inter alia, "Dad, come here, you've got to see this," which has been debunked. Bruce, you want to explain that?
Well, I mean, we didn't debunk anything. I mean, this is somebody's claim.
Okay.
Post the trial, and it's their personal testimony. Now, I have another source who has conflicting personal testimony about how these documents came about. So I don't know that I would call that debunking. It's just there are different stories about what happened there because humans are unreliable narrators. So I don't know what to do with this stuff.
Do you guys remember do you remember who it was? I don't even remember who said that.
Yeah.
Someone I don't really know.
Okay.
Put it that way.
I can tell you in the private chat, but the other problem he does here is he says there are all these people that said this sentence, and it was one person who said that quote sentence at the end. I mean, there were people talking about all sorts of stuff, but like he misattributes the quote to multiple people instead of just one person, which I find suspicious.
Mm-hmm.
But in any case, there are conflicting testimonies here. And I think, like Patrick was mentioning before, there was no investigator that went and interviewed all these people and got, depositions or like it's all just stories, right? So I don't know what to do with it.
Mm-hmm. Yeah, I don't. I've never met that person outside of that date. The person who said all that, and then. I haven't talked to them since then, so I don't really know what was going on and why they said that. Maybe they were mistaken. Maybe they were just exaggerating for effect. I don't know. That's one thing I don't know. So.
And again, it's a question of fact, so the court's not going to review that, and the presiding judge already found it. The overall conclusion not that it didn't create bias.
Yeah. Mm-hmm. Okay. Right. Among other things, these supporters, like Mr. Howe said, we went through that already. Okay. Second, and far more concerning, after receiving the court's post-trial ruling, Laura immediately noticed one of the most critical factual findings was not based on any evidence. Wow. Evidence admitted at trial. Rather, the key finding appeared to have been copied from a social media post made by an anonymous third party after the trial concluded.
This fucking annoys me so much because he's assuming that she couldn't have gotten that information from anywhere else.
Well,
that she couldn't have already known the information, that she didn't Google it, that she didn't ask a family friend, that she didn't talk to Dr. Deans outside of this annoys me.
Yeah, I mean, there's a myriad of ways this could have occurred.
Yeah.
And you don't know how it occurred. But what he does is he speculates and he picks out the option from the myriad of ways this could have occurred that is best for his case. And he inserts it into his filing as if it must be the most likely answer or is the answer, which I find disingenuous.
So dumb.
I can't say for sure this is where it came from, but I can give you one possible source where it came from. Somebody did send me screenshots, and this was a while back, a stream I did a while back, where somebody sent me screenshots of where people had commented on David's blog or responded to his tweets.
Oh, well, he posts a blog picture on here.
Okay. Well, they were saying in their responses that, Planned Parenthood was closed on Sundays or whatever. And that made it, his tweets made it into the exhibits and his blogs made it into the exhibits. So, there's a possibility that he's the reason she knew that.
Those are post-judgment exhibits, though.
I don't know, man. Because they were before June 10th, for sure. Because these people sent me screenshots from where they had commented.
But no one knew that Laura was going to claim Los Angeles on June 10th.
That's the issue.
So, yeah.
But July 2nd, though.
But they're saying because it's a different location, how would she have known for sure that location in Los Angeles was closed on a Sunday on July 2nd.
I mean, she could have just assumed because she could have assumed all of them were closed on the
No,
Sunday.
of course. It's so fucking dumb. He's saying that, oh, it's because this social media thing. That's so stupid.
Yeah.
But you're saying there is a filing that is before the judgment.
I'm not saying that. I'm not saying the filing because we can't see the exhibits. Like I tried to get them and we could not get them. But in the
you're saying there could be an exhibit before the final judgment that talks about some Planned Parenthoods being closed on Sunday.
Do you mean the June 10th exhibit?
Not the June 10th. Well, the ones that went right before the trial. What were they called? Pre-trial motions or whatever.
Yeah, where they have. There's a list of them, but we didn't get to see the actual.
And his tweets and his blogs are in there.
Interesting. Yeah, there's a bunch of stuff we don't have. Like we don't have Dr. Dean's full report. We only have the experts that he leaked.
Are we allowed? Are we allowed?
Why we can't see that? I just want to know everything.
I know, right? Yeah, each side before the final hearing had their pretrial statements or whatever. And of course, one of these presumably is the one that was printed out and given to the guy in the line who just happened to be the judge's father, apparently. Not given to him by the judge, at least according to my source.
I mean, he in any case, direct evidence of it. Doesn't have it.
Yeah, I think, and DSG and LO, he had in one of his videos, well, we sat down and we scrubbed through all the documents and we couldn't find any mention of LA or, I don't know what their search terms were, though. Maybe they searched for LA, but I mean, maybe there was something that was similar to Planned Parenthood being closed on Sunday in LA.
Yeah.
And that's where the judge got it. I just don't know.
Yeah, she didn't say anything. We don't have any of her pleadings either.
The only information we have is that Judge Fisk said this doesn't matter.
Right. It's a moot point.
He says it's a very serious thing in here. So clearly he disagrees with Fisk, but it's like, well, I don't know what to do with that.
You can't relitigate it.
Yeah.
Also, I wanted to say this is kind of a non sequitur, semi non sequitur. I had called Mission Viejo and they told me with the story I presented them that they do offer ultrasounds. I know that was a conversation a while back where people were saying they didn't. I was told by an employee there that they did in fact offer ultrasounds.
Okay.
Huh. But no one's ever said
Mission Viejo then.
Well, people were saying that she couldn't have even gotten one there when she claimed she went there and got one because they don't offer them. But
right.
But I was told by an employee that they do offer ultrasounds.
Yeah. Well, the thing is, like, any medical practice like that, you're not going to be able to walk in anonymous. And if you do try to do that, they're either A, going to turn you away because you're refusing, or B, because you're insane. And if you're like delusional and crazy and you don't want to give them your identity because you're paranoid, they're going to send you to the ER. So you don't just walk in there and get something done anonymously because that's what
really about with a fake
big
name?
Liability. Fake name, still no big liability. You gotta have your ID.
I have been to Planned Parenthood, and I had to show my ID.
Yeah,
I had to show a driver's license. Yeah. That's what I had. So that's what I showed.
So this whole thing it's completely unresolved. Like how this could have happened anonymously or with a fake name,
because it couldn't have.
Unless she had a fake ID and that's her story, in which case that's would be
federal
more
crime, isn't it?
That would be more crime.
Yeah.
And then there would be a record of her visit.
Oh yes. And we would, you could go get it.
Emily Laura Wilson.
Or whatever the name was in the fake ID, if it was fraudulent. That would just be more crime. So, they should have just paid the bill and left.
Yeah, but it's not going to happen, I guess. And I think, I don't know how long he's going to be willing to stick this out pro bono, but she's never going to let it go. Unless she goes to jail.
Probably not. I don't,
Let it go. Let it go.
Never let it go.
You dumb fucking bitch.
Oh, I should give chat a clarification. I looked up both of the statutes that Clayton cited, and I think it's completely reasonable because he's a normal person. This one of the statutes he cited was for civil sanctions, and the other statute he cited was for reimbursement of the paternity testing costs. So that's not necessarily a sanction. And then the civil one is interesting, but I think that'll be something if they choose to latch on to that, they would have to address. So not exactly a slam dunk, basically.
I agree with people in the comments. The only way she's gonna stop is to go to jail, and I've said this before, but like people with certain types of, and I have not given a specific diagnosis that I think she has. I think that's not my place, but like people with specific disorders, people with specific personality types, you can't just force them to be rehabilitated. They go to therapy. If they're forced, they lie to the therapist. They just want to get out of there. Like they just want to come off like they're better than everybody else, especially if they've got a little bit of narcissistic stuff going on there. Like they're not going to tell the truth, and therefore they're not really getting treatment, even if they're sitting in a place to get treatment. So like you're not going to do anything for that person unless you put them in jail, which is where they need to go to get rehabilitated, because they don't want to go back to jail. They want to be out in the world where they can feel like they're better than everybody else. So they, in order to do that, in order to live a normal life, they have to learn how to behave in a way that they will not go back to jail. And that's just my experience with people that I've seen and who have gone through treatment and come to the hospital over and over again. It's like they don't stop until they have to. So.
Yeah, just going back to like the fact that this doesn't change anything. Like if this gets dismissed and Laura feels like she can say, still feels like she can say, I was pregnant by the Bachelor, that's, Clayton's going to either have to deal with that legally or just sort of do what Bruce said, just like walk away.
Yeah, I mean, he can, but I don't think she will is the problem. Even if she gets this dismissed, I think that she wants to punish everyone who has ever rejected her or punish everyone who's ever called her on her shit. And that's why David keeps saying, I'm going to war with JFC. We're going to sue everyone who said this and that. And like Dave Neal's going to get, sued and he's going to regret it. And like, it's because like she won't give up. Like ever, unless she is punished by the actual justice system. I don't think that she will give up.
Yes, and I also, to add onto that, I think the reason she is so fixated on Mike is because that was the first time she was able to truly, like with Matt, with the first person in 2014, she claimed pregnancy. Lawyer said, yeah, go see my OBGYN and let's see if you're actually pregnant. Like show me the ultrasound and then we'll talk. She dropped the case and then a week later claimed she had a miscarriage. Right. With Mike, that was the first time, because I personally do believe the napkin note is real. But completely out of context. Right. Not that person not understanding.
Yeah.
So that gave her first taste of like being able to be a victim. Then she never claimed any of this sexual assault, violence, all that stuff with Mike until after he told her he was leaving town and moving away. And then she saw him like 6 months later in town with a blonde girl. And that's after that encounter is when she claimed all this stuff happened. So I think that Mike's case, her whole victimhood hinges on Mike's case. And if that can be disproved, I don't know how to say it. Anyway, disproven that that is just gonna like fucking blow her shit up. And that would expose her in all of the ways. Does that make sense? So I think that's why she's holding on so tightly to him and to that case.
Right.
I've thought that for a while. Yeah, that's her character or origin story.
Yes, exactly. The TEDx, the chicken soup, which now is taken down in certain places, right? But that's, yeah. Anyway,
TEDx is gonna eventually have to pay attention.
Yeah.
Man, the fact that Omar is in California and Mike is in California, like,
dude,
so ready for that.
If you're not a praying person, send vibes. Send vibes that maybe that
happens.
Maybe that could happen.
Because overall, restraining order cases aren't that hard. Like, it's basically a he said, she said. Obviously, Laura made it insane. I cannot believe that docket. I spent a whole summer filing. I think I told you guys already. Restraining order dockets, or like organizing them, and I've never seen a deposition ever. So if they could streamline it, I don't think there's any need to take a deposition again, except for as to the fraud.
Right.
You know, this could be something that he gets out of with not a big bill either.
I'm hoping that like he can at least make it so she can't renew it. Now, I think it's a tall order to get it expunged from his record.
That's so sad.
It's hard to disprove, for example, sexual assault. It's going to be hard for him to disprove that.
I'm thinking about the pictures where she claimed DV and where we have the lot number that's the same on the gown, and she was also claiming that was from when she had what was it, like an ovary removed or something. Like I just don't want to believe there's nothing that can be done. You know what I
don't think it's nothing, but it's also like how aggressive does he want to go for it? And how much evidence can we, even if we uncover from the doctors who she claimed wrote those letters, even if we can get them to say that that's fraudulent, even if we can get David Katz, the manager, to say that those emails and texts are fraudulent, even if we can get that, it's just the act of the sexual assault. Just because she doesn't have proof doesn't mean it didn't happen. It's going to be hard. It would be hard to do that, but the easier task is the getting it not renewed. But I mean, you can always try.
Yeah.
And she will. I mean, I don't think she can help herself.
Yeah.
I don't think either of them can. And the fact that he's barred in California means this man is, no wonder he bought all that equipment, now that I think about it.
Right?
Oh my God, he fucking found his fucking golden goose. This is just,
and he's trying to poach JF Sears.
Yeah, she's literally a cash cow. Like, he can follow her to Mike, he can follow her back to Greg, like, and he doesn't even have to ask for a lot of money if he is gonna, hard launch this career. He could just do it off that. That's just, dude, Gingras.
Yeah, and
it's not if he fucking sues me, he's not gonna get anywhere with that because nobody's gonna want to touch him.
Yeah, you don't. Well, I'm saying Laura will be his only client.
Oh yeah, no, sure, but I thought you meant like with his new venture and like YouTube and stuff like that. Like, he's not going to get anywhere with that. Not if he sues someone who, like, in good faith was being kind to him and like tried to help him out, and like he's like, "Oh, I'm going to take you for 150 grand, like, for my one client who doesn't pay me." Like, you're not going to get anywhere with that.
Did you know that like basically overnight he gained like 500 followers? I wonder who bought those for him.
Honestly, so I said the same thing.
Oh, really?
I said the same thing. I was like, I bet Laura bought those for him. But at the same time, I'm like, I'm remembering when I went on Dave and Megan's show and how fast I grew after that. And I'm like, well, Ian Runkle did just, do a thing on him. And so I'm like, well, maybe he got some from
people
that.
who don't know better.
I'm saying we don't know. I'm saying we don't know. but it's a possibility.
Yeah.
I got bored one day and did one of those, like, is this account like buying followers on some Nobody Told Me?
Oh,
and I've got the report here. I can send it to you guys if you want to see it.
Yes, we should show that.
Yeah, go ahead and drop me an email. I'll definitely.
Zentz says, if I have sex with a girl and she has a baby, I can prove it genetically. Do I really have to explain this? Apparently you do, dude. Because there were no babies in this case. And so he had to do a paternity test multiple times. There was little to no fetal DNA, and that still, he still had to go through the whole thing to get a finding of non-paternity. So, unfortunately, yes. The answer is yes. Let's see. Where were we on this? Immediately upon discovering this extremely serious misconduct by the trial judge, Laura filed several pleadings, including a notice of change of judge for cause, supported by an extensive affidavit of counsel. Laura also moved to vacate the judgment, move for a new trial, and moved to alter/amend the judgment. Simultaneously, Laura also reported these matters to the Commission on Judicial Conduct, which opened an investigation, which remains ongoing as the date of this brief was filed. Okay, sure. On July 18th, despite having no authority to do so while she was subject to a pending notice of change. Oh my God, shut up. And before Clayton filed any brief opposing the motion, Judge Mata denied Laura's new trial motion and her request for other relief. Several days later, after this apparent act of retaliation was reported to the Judicial Conduct Commission as a violation of Commission Rule 14, prohibiting acts of retaliation by a judge in response to a complaint to the Commission, Judge Mata issued a new order withdrawing her prior order, claiming she was unaware of the notice of change of judge that would suspend the court's authority. So, like, I read the beginning of that, and I'm like, this looks pretty bad. And I just don't know how to feel about it, to be honest.
What do you mean it feels bad?
So, like, I look at the beginning where he's like, she denied it while she was under investigation, or like it was an act of retaliation while she was under investigation by Judicial Conduct Commission. And I'm like, okay, but this like looks bad if you take his word at face value. But
also, well, if she wouldn't have rescinded it if she were trying to retaliate, right? Why?
That's what I don't totally understand.
Well, it's because he doesn't make any fucking sense. That's why. It's not you, it's him.
Oh yeah, sure. Okay, so this it's false. There's nothing left to talk about. Right. Okay, but apparently there is.
Apparently, I mean, he does this thing again where he says, "Oh, it's an apparent act of retaliation." Like he just dismisses any other possible logical alternative and goes with the one he likes the best.
And like also he's one to talk because he missed the subpoena for Mike. He's like, it was in a 73-page. Oh well, yours is fucking 73 pages, bitch. All right, it was in a 73-page filing and I didn't see it. Well, what if she didn't see it? What if she had other things to do and other people to see?
Actual
like
people,
you.
Oh man.
Wild with the retaliation in there. I mean, but he started it in the first sentence. He called her out. So I would have, if I was going to call her out anywhere, I might have said it something like that, but a little bit less harsh in this, in this possible sign of retaliation. But I wouldn't have led with it. Page 1.
Yeah. Okay, let's skip down a little bit. In her order, Judge Fisk recognized Laura correctly points out that Judge Mata's July 17th ruling contains a factual error, i.e. the transcript from the June 10th hearing shows that Dr. Samantha Deans did not testify that Planned Parenthood is not open on Sundays. The emphasis added. Despite this, Judge Fisk concluded the evidence failed to show Judge Mata independently investigated the facts. Well, the court finds Laura relies on mere speculation and suspicion when alleging that Judge Mata engaged in a secret, undisclosed investigation and is therefore biased. That's what happens when you clip a small YouTuber's like video as your proof, with like some random person talking that we might have met once. Like it's not really. It is speculation and suspicion. So.
Yeah, you have to back up these claims are very serious. And you have to back it up with serious evidence.
If the girl that said that on the stream was like Judge Mata's aunt or something, I could see why it would be a problem. But she's just a random person. So.
Well, at least he quoted Fisk saying mere speculation.
Right. Okay. Despite this, Judge Fisk could not explain and did not explain how Judge Mata could have properly found Planned Parenthood is closed on Sundays, since no trial testimony or evidence addressed that issue. Judge Fisk ultimately brushed that concern aside, concluding the question of Planned Parenthood's business hours is of little to no importance, given the rest of the findings in the July 17th ruling. I mean, that's kind of true, though.
Kind of true, though.
After Judge Fisk denied Laura's notice of change of judge, she authorized Judge Mata to rule on any remaining issues. This resulted in the court granting Clayton's request for fees/costs in a judgment entered August 19th, and denying all of Laura's post-trial motions for a second time.
Fuck yeah, it did.
The timely appeal followed. As explained in Laura's notice of appeal and her amended notice, this court has jurisdiction pursuant to ARS 12-2101A1, 12-2101A3, 12-2101A5A, and I'm tired.
But was it a lengthy notice of appeal?
Notice.
Oh, man. Okay. Statement of issues. Issue 1. So many issues, bro.
There's just 5 here. I think you can get through these, and then the rest of it is all the law.
I thought we were listing the client's issues here.
I only reviewed and read cases through issue 1 anyway. So,
oh boy.
Issue 1, as a matter of first impression, when a party files a motion seeking sanctions for an alleged violation of Family Law Rule 26, but that party does not comply with any of the procedural requirements of the rule and later withdraws the motion, may the trial court nevertheless award Rule 26 sanctions sua sponte in a matter that wholly ignores the procedural and safe harbor requirements of that rule. That was a run-on.
Huh.
And assuming sanctions were unavailable under Rule 26, did the trial court err by sanctioning Laura for a Rule 26 violation using its inherent authority or other law? Okay.
Which it never did.
Issue 2, did the trial judge commit structural error entitling Laura to a new trial by conducting an independent investigation into the facts? I mean, is this guy if they were to get a do-over and she got what she wanted with a jury trial or something, I feel like this guy would just age 1,000 years.
They would be so fucked. They are so dumb for thinking that would be good for them.
Now, why would there be
good for her?
I don't think he does think that. I think she thinks that.
I think they would request a jury trial. She has a right to a jury trial.
I think that's what she wants. I don't think that's what he wants.
Yeah, Patrick, is that how it would work? They'd have to do a filing for a jury trial in family court or something on a retrial? How does that work?
I'm not sure if family court in Arizona allows for jury trials. I know that Texas does. I'm not sure of Arizona.
I think it does. I think that it is possible for her to get a jury trial.
But
jury would be so bad.
What he wants is them to just basically say, the only thing that was left was Rule 26. Neidigh and Woodnick both screwed up Rule 26. Greg by not giving notice, and Neidigh by not having a show cause hearing for sua sponte sanctions. And so since they both screwed it up, reverse it and be done, and order the dismissal, because sanctions aren't allowed after the dismissal. But that's only when sanctions were removed for after the dismissal was filed. Sanctions were removed for before they were filed. So even if he gets everything he wants, I still think they reverse it for a new trial, which they definitely don't want.
Right. Think of all the evidence that has come out since then that would be so bad for them.
Her lawyer saying that no doctor ever told her
that it's her sister's sonogram.
Oh yeah, the sister sonogram, the boy-girl twins. Can you imagine Deandra just grilling people about this? That would be unbelievable.
Mr. Gingras, these are yes or no questions.
That's amazing.
Oh boy.
Oh man. Okay. Issue 2, did the trial judge commit structural error? I think we went through that. Issue 3, did the trial judge or the trial court err by awarding sanctions under ARS 25-324 and or 25-415 when there was no basis for such an award and no motion for sanctions under those statutes were ever filed?
No. I can answer all these questions.
Wow.
Yeah, because Clayton's one of Clayton's requested orders was Section 25. So that door is open, bro.
Yeah.
All right. Issue 4, did the trial court err by awarding legal fees of $150,000 when the alleged misconduct did not cause those fees to be incurred? What?
No.
And no jury trial for family law in Arizona.
Yeah. Cool.
I thought I heard from someone that was a possibility. I'll have to double check on that. I know you just checked. I don't mean to.
I'm just looking at the top Google answer, so you should be skeptic. I can't speak. Whatever. I'm gonna get another beer.
There's nothing wrong with being skeptical. We can always. It gives you.
I'm trying to, I guess, place what I heard with that information and trying to make sense of that.
Mm-hmm. Is Laura entitled to her attorney's fees and costs on appeal? No. No.
I mean, if you're going to ask for everything, just ask for everything. I mean, go the whole 9 yards.
Go big or go home.
Yeah.
And then here's like the arguments: Clayton's failure to provide with the safe harbor requirements, blah 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 blah. And I'm not going to read all that because I'm not a lawyer. I'm a layperson, and I'm cool with skipping it. I don't know if there's anything else of substance we need to.
There was something near the end that was making me laugh. I don't remember what page it was on. Maybe it was the Laura's entitled part number 5. Might have been that.
Oh geez.
Wait.
We really need Omar and MG Law and Legal Vices to look through the rest of this document and pick out the parts that they want to talk about.
So we're going to D. The award of fees was erroneous because the fees incurred were not necessary nor reasonable. 1, citations to record and standard of review. Here, after Clayton applied for fees and costs, Laura objected. Among other things, Laura noted an award of fees was factually improper for one simple reason: because Clayton did not incur any fees prior to the time the case was scheduled for an administrative dismissal. Laura also noted the amount of fees was patently unreasonable in light of the controlling standard of ER 1.5. What does that mean?
What?
I don't know what that means.
I don't know. Obviously, basically, she's saying that there's no way he should be able to charge as much as he did, and she shouldn't owe $149,000. Blah blah blah.
Okay, Mister.
We would have to go over the controlling standard of ER 1.5.
When he's talking about raising his fee to $800 so that they're going to pay more. He said that.
He said something like, he's doing this appeal for free, but if they get a reversal on sanctions, he's going to charge more than Woodnick.
Yeah.
Like it's the classic dick measuring contest.
You only do that when you have no dick.
He asked for fees in this as well. Like, we should skip down to that. It's very short. It's ridiculous.
Yeah.
Okay.
That's in like the issue 5 section, I think.
Okay. As noted several times above, when a fee award is challenged on factual grounds, an abuse of discretion standard applies. I'm not reading that. To a discussion, again, because this appeal may be fully resolved on other grounds, the court need not address this point. However, it is worth briefly explaining that even if Clayton's position was correct, and even if the trial court had the ability to sanction Laura under Rule 26 or any other legal authority, that does not mean the award of nearly $150,000 in fees was appropriate here. The simple fact remains that even if Clayton's factual allegations are true, and even if Laura was never pregnant, which she obviously disputes as vigorously as possible.
Really?
The filing of
not being in dispute.
The filing of Laura's.
What if in order to dispute you had to twerk, and then she was disputing as vigorously as possible?
Oh boy.
That was her defense.
She's vigorously
takes a
twerking.
dark turn.
The vigorous twerking is ongoing.
That was extremely random.
Oh, well, my son was like twerking the other night.
What do you do at home?
No, we were listening to some music. He was feeling it. And we were like, "You're twerking."
Okay.
Have you ever met kids, Lauren? They're kind of crazy. They just do
I don't know
wacky
any
stuff.
kids who just voluntarily twerk, and that's because I don't spend time
They
with
do
them.
weird things.
Anyways.
They do very weird things.
No, I
love that.
I twerk, but like not a lot. Only when I'm trying to make people uncomfortable.
Not a lot, baby girl, just a little bit.
Oh, boy.
Just a little bit. When I'm trying to
I
make
have
people
share
uncomfortable.
anxiety. I'm going on a trip after Thanksgiving, and the girl I'm dating really likes to dance. I cannot dance to save my life, and I've hyped myself up. So I'm like, oh, I'm gonna freak you down at the club. I have no idea.
Patrick, as a thank you for being here with us tonight, I'm going to show you what to do.
You're going to freak them down?
This is your girlfriend.
Oh,
Okay.
No.
Oh my god.
Oh, no.
In the club.
I like how there's a shadow. It makes it more boring. Oh.
I just want to point out you jumped. You actually jumped.
Yeah, I'm not that tall.
Oh, okay. Thank you. I needed that for I feel better now. I know what to do.
Wait, but how long have you been dating? Let's see if it's safe to pull that move.
No. You can pretty much
the I
do
love you's been
anything else,
thrown
and you'll
out.
be fine.
Now, what if you go to the restroom and you come back and she's dancing with someone else, salsa
Right.
dancing?
Oh no, she would never. Mm-mm.
But what if she is?
If she is,
What would you do?
I mean, I guess I would like try to make eye contact. She'd probably see me and come over. Or she would probably just be looking really sketched out and like save me.
What if
in
she
which
waves
case
and
I would
keeps
come over.
salsa dancing with this guy who looks like Aquaman? Who's the Aquaman? Jason Momoa.
Man.
If it is actually Jason Momoa,
Well, no,
then
he just looks like Jason Momoa.
Oh. It depends on what she looks like. If she looks like she's having a good time, I play it one way. If she looks like she needs help, I play it another way.
Okay.
This was a scenario on a FLAD episode with Omar, by the way.
Do you? Okay, so
we're
fine.
testing you against Omar's answer, basically.
So if she looks like she's having a good time, I go to the bar, I take a shot, and then hopefully the song is over by then, and then I go over and like step in.
But this guy's trying to take your girl.
No, sir.
Wait, you keep moving the goalpost, Bruce. Is he dancing with her? Is he like is he Laurening her on a chair?
No.
They're salsa dancing.
You grab Jason Momoa by his long hair and you swing under his legs with it.
Oh boy.
I think I get in there. If it's Jason Momoa, yeah, maybe I just act overly tough. Like, hold me back.
I think maybe you just fuck him first.
Would you start doing some grinding? Yeah.
I would never try to dance between them. That would be where I would
You don't want to get lost in there.
So funny.
Yeah.
I said
that you're going to get pegged in there, but that's fine too.
I said if my husband were like trying to I went to the bathroom, came back, and he's trying to dance up on a lady, I would have a drink and sit back and be like, "Good luck, man.
Oh,
let's see what you can do."
Okay.
All the
we have
best.
similar responses.
Wow.
Dance off would also be up there, but I can't dance. One move now, the Lauren.
I feel so sorry for you. All right. Okay. Anyways, had Clayton's counsel simply picked up the phone in mid-December and asked Laura about her intentions, I'm certain that happened. Required him to do family law rule 9C or whatever, she would have informed him that she was no longer pregnant and there was nothing further to litigate.
He's speculating here. This is speculation. There's no guarantee that any of that would have happened the way he describes it. This is
which
just
of
baseless.
Which of the 13 phone numbers should they have called?
Yeah, this is just baseless speculation. Like the aliens could have stolen the babies. Like, I don't know.
Patrick, since Laura testified on June 10th during her cross by DG that she filed this claim in court in case Clayton was determined to be the father, how can she legally file if not 100%?
Did she say that?
Patrick, why don't you dance around that question?
Oh, I'm reading a question in the chat. What was it?
Oh, the one that they just read for you. Patrick,
oh my god, I was reading that.
Oh my god, your ADHD is worse than mine. Do you have ADHD?
He's doing what we want, Lauren. Leave him alone.
I cannot do two things at once. That's for damn sure. Why I'm not also in trial court.
There you go. I put it on the screen for you.
June 10 hearing her cross. IG that she filed this claim in court. Oh, so this is a great question because this is what I thought the basis of appeal was going to be. And I never said it out loud, but I always thought that the basis of appeal was going to be exactly this, which is she didn't have to be 100% certain. And that would be the statute.
Yes, he's been saying that. I feel like he's been saying that the whole time. Like, we don't need to prove or disprove she was pregnant. She was ever pregnant.
Yeah, so I would just say the statute that governs like the whether or not paternity is established does not require 100% proof, and but the thing is, it doesn't actually have any measure of proof, whereas some jurisdictions require 50% proof, like some proof, like a sonogram Like some jurisdictions require that. And he could say the law is ambiguous and it needs to change such that, a P test is enough to establish the right to file this case. And then he wins everything. But I didn't want to put that out there because it was a substantive argument, and I didn't want him to think about it that way. But yeah, he totally didn't even bring up the fact that the statute may have been misapplied. But then again, just to be devil's advocate to myself, that portion of the case did get dismissed, so it is kind of moot now.
Right. Yeah. Right.
Yes.
Hopefully that answers it.
I hate when he says here again, at that point, Clayton's fees were literally $0. Yeah, if you want to just go on and be abused by her and not do anything about it.
I think, I understand like legal fees, yes, but also think how many hundreds of thousands of dollars he lost in work and how much she would continue to attack him moving forward in the years to come and make him lose money because of that. Yeah.
I think those things are the things where he's arguing you have to initiate a separate defamation case.
You would. But I mean, my mind, when I was reading this, I'm like, I know legally it's not really.
Oh, yeah. I mean, emotionally, yes, that's the argument. Yeah.
There's simply no legal authority of any kind to support what occurred here. Clayton asked the trial court to force Laura. Hold on. You want to talk about forcing someone? Laura forced Clayton to involuntarily continue litigating this matter. And then he asked the court to sanction her for continuing to litigate this matter. Hello? Like, she brought a false pregnancy claim. Like, what do you expect? The trial court's decision to permit this sham. Why do I feel like he's talking about his client?
Exactly.
Was clearly an abuse of discretion in every sense of the term. Are you kidding me? For that reason, even if all of Laura's other arguments are rejected, this court should still reverse the fee award in its entirety on the basis the trial court abused its discretion in both the legal and factual basis for the award.
It's like when you start blaming 1, 2, 3, 10 other people, all the people around you, maybe you're the problem. Maybe your client's the problem. No, it's Woodnick. No, it's Fisk. No, it's Mata. No, it's blah, blah, blah. No, it's actually your client.
Well, my thing is, like, he wants to argue this stuff and hope that, the legal system will agree with him based on, like, technicalities or whatever. Yeah. But my thing is, he has dove in, I think is the word I want to use, dove into PR with Laura, and he wants to win over the public. So you can't just use this, right? Because we're smarter than that. So even if you can get off on a technicality in the legal system, the public knows better. We know when we're being lied to. We can see things that aren't admissible in court, and we know better than that. So you can't just try to dupe the public the same way you would try to game the legal system. It's not going to work. So when you insult people they don't know the law, blah, 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 I'm like, okay, well, maybe we don't know the law, but we know a liar when we see one. So
and
if
all
you
they
want
care
to
about is
stick
the
to
win.
law, stick to law.
Yeah, I think his big mistake here was trying to do PR and file these motions and be the lawyer at the same time. I think that was the major error.
Right. All right. Let's see here.
And then he didn't know himself well enough to know he shouldn't do PR.
Yeah. Laura gives notice that she seeks an award of attorney's fees in court in this appeal, incurred in this appeal, pursuant to ARS 25-809G, permitting in any paternity proceeding award of attorney's fees, deposition costs, appellate costs, and other reasonable expenses the court determines were necessary.
Just even seeing this line, Laura is entitled to fees on appeal, made me laugh.
I know, I can't believe it.
That's wow. In the proceedings
below, swing hard.
In the proceedings below, Clayton committed multiple violations of the rules of family law procedure, including but not limited to filing a Rule 26 motion for sanctions without complying with the procedural prerequisites of that rule.
Clutch my pearls.
Of course, Clayton later withdrew his Rule 26 motion after Laura's counsel threatened to seek sanctions under Rule 26 on the basis Clayton's actions violated that rule. What did you not threaten, my guy? All right. Because Clayton invoked the safe harbor rule of the safe harbor of Rule 26, Laura is not requesting sanctions against him under that rule, really, because Laura said in one of her blogs that she was going to try to report him for fraud. Fraud!
And extort him for, like, what was she said she was going to sue him for? How much money?
I don't fucking remember. Nevertheless, Clayton's other conduct is more than sufficient to entitle Laura to fees under ARS 25-809G. Clayton continued to aggressively litigate this paternity establishment action, despite knowing Laura was no longer pregnant. Well, she was never pregnant. He knew she was never pregnant. Mm-hmm. That's different. The fact alone was and is sufficiently unreasonable to entitle Laura to her fees on this appeal. 5. Conclusion. For the reasons stated above, Laura respectfully asks this court to reverse the trial court's judgment in its entirety and remand this matter with instructions to dismiss the case with prejudice. In the alternative, Laura requests an order reversing the judgment and remanding this matter for a new trial. In either case, Laura also requests an award of fees and costs incurred in this appeal.
She's crying.
Yeah, that's not even the proper remedy. Based on all of his arguments, the proper remedy would be reverse, have a new trial because Judge Mata was biased, or reverse and make Mata have a show cause hearing for the Rule 11 or the Rule 26 sanctions. Yeah, there's all of the outcomes result in a new trial. They don't result in just complete dismissal.
Mm-hmm.
Maybe not.
They
all,
want.
right?
They want a dismissal. They don't.
Want that.
Yeah, exactly. Yeah.
They certainly wouldn't want a new trial with the same judge. If, like you mentioned, an option where you're just going back to the same judge.
I think you wouldn't be able to go back. You automatically don't go back to the same judge, I don't think.
Yeah, that's what I thought. Okay.
I mean, the longer this drags out, the longer it is before she can fake another pregnancy.
Seriously, she's usually a May girl.
Right?
Low key, if you know, you know.
Valentine's Day babies.
Yeah, she's
right
got
before the circuit.
She's got a while to wait now, like 6-7 months.
I know. That's why she's so thin. She's just like, actually, I'm not going to comment on her body, but she's definitely out there. Just like, I mean, she's probably still on dating apps, I would imagine. Like, she is codependent enough that she needs that.
Yep.
Yeah. All right, guys. It has been 3 hours and 15 minutes. So I got to get to bed. I have to work early, and then I might be stuck here for a while. So I don't know. If I am, I'll go to House of Prime Rib. If I'm not, I'll go home. We'll see.
Heck yeah.
Thanks, everyone, for being here. Thanks for all your support. And we will see what happens tomorrow. Or, you know what? It's only 9:45 here. So I might go ahead and file that counterclaim tonight. So we'll see. I'm going to do it before I leave San Francisco, though. So I'll come back and let you guys know how it goes. We'll read over what I said as soon as I submit it.
And you gotta record yourself hitting send.
Oh, I will. And then if he decides to sue me, then we know he's full of shit and he's not really trying to be a better guy. So that's all good.
Oh yeah.
I'll be okay. Whatever happens. It's just going to be really fucking stressful. So, all right. Bye, everyone. Thanks for being here.
Bye.
Bye.